Good afternoon and welcome to Garden Court Chambers. It is a huge privilege to be here to welcome you, not least because we're marking World Children's Day and we had another event in Chambers on Monday, but because even though this is such a challenging time for children's rights internationally, never could there be a more important time that domestically we get it right for children. We should be a shining example of children's rights in England and Wales. And this afternoon we're going to examine what that means for children in detention. And I'm also hugely privileged and excited this afternoon because what this conference represents is an opportunity for lawyers who have an expertise in children's rights to learn from each other and to foster a cross-disciplinary approach to different cases that we may find ourselves dealing with. Because invariably children don't just have a legal problem that fits neatly into one category of law. Invariably there's a crossover between different areas of law, but also that we can learn from the approach one area takes in order to improve the way we represent children in another. We also often need to work together, to work with community care lawyers in criminal cases to understand how children can be supported to avoid them being remanded or sentenced to a custodial sentence. Similarly, to learn from our immigration colleagues to avoid consequences of criminal proceedings that will lead to their deportation. We're going to start this afternoon by thinking about children at the police station. And that's the beginning of the journey for many children at the start of the criminal justice system. In many ways, it's the most important moment, and if we can get it right for them, then we avoid them coming into the formal criminal justice system and being further tainted by that experience. And I am hugely privileged to introduce two really expert speakers. We have Dr. Miranda Bevan, who's currently a lecturer in criminal law and criminal justice at Goldsmiths University. Miranda and I actually met when we were both criminal barristers. It feels quite a long time ago, and probably was. She did practice as a criminal barrister at Two Hare Court, the chambers of Jonathan Laidlaw QC, for over a decade. And then she moved into academia, and her journey into academia took her to the Law Commission. And one of the projects she worked upon was unfitness to plead. And there is an excellent report, and the section on children, or I expect youth justice, is written by Miranda, and I'm really pleased to say that the recommendations that are made in it about requiring a very different approach to how we address fitness to plead in the criminal jurisdiction their recommendations have been accepted by the government. We'll just have to wait for their legislative time in order for those recommendations to be implemented. She has also worked at the Howard League for Penal Reform, and her research now focuses on the experience of children and young people detained as suspects in police custody, informed not least by her PhD research. And she's also interested in the effective participation of children and vulnerable adults in the criminal justice system. So we're very privileged to have her here to talk about her recent work about children at the police station. And she also, it doesn't say here, but she also convenes the APPG on children in custody, which had her busy last night gathering evidence for the brilliant work that they're doing there. We also have Dr. Vicky Kemp. She is Principal Research Fellow and Co-Director of the Criminal Justice Research Centre at the University of Nottingham. She is an experienced researcher, having conducted extensive empirical studies into youth justice, police custody, and police station legal advice. Vicky and I met some time ago and she is a force to be reckoned with. She has been determined to improve the treatment of children at the police station, and she is doing so because she has an evidence-based approach to her research, and she is uncovering a picture of what is actually happening at the police station that we didn't know before because there was just not data available to understand it. She's been funded by the Nuffield Foundation and has recently completed a project examining the impact of PACE, Police and Criminal Evidence Act, on child suspects for the first time in England and Wales. This included engaging with children about their legal rights while held in police custody. This is an impressive feat given that most of that research was done during COVID. And it shows the extent to her commitment to this, that she managed to engage with police forces to get the permissions to get into the police station at such a challenging time and hear from children at first hand their experiences of police custody. And she's been able to bring that together with empirical research and examining tirelessly custody records, which she's going to tell us a bit more about this afternoon. And she's also going to tell us about her second Nuffield funded study with Dr. Miranda Bevan. Thank you very much.
Thank you very much for inviting us here today. Right, what I want to do is to go quite briefly through the findings that we've had from the first Nuffield study. So we were looking at the impact of PACE on the detention and questioning of child suspects. We examined over 50,000 custody records drawn from 8 police forces, and that included 3,772 children. That's the largest study to date. And the last study of electronic custody records, which I was also involved in, was 2009. We undertook 3 case studies, which enabled us to look in depth in 3 police forces and 8 custody suites at what's actually happening. And that meant engaging with children while they were detained. And that's been the first time since PACE that researchers have done that about children's legal rights. So we also spoke to other people involved in the process, but we were able to see the process through the lens of a child. I've been doing this work for some time, and I either look at a defence perspective, a police perspective, but this is the first time that we've actually got the perspective of the child, and it really opens up what's going on. In this talk, we want to talk about the UN Convention on the Rights of the Child. It's not mentioned in PACE. We're looking at understanding participation and decisions made in the best interests of the child. Perhaps focusing on legal safeguards, legal advice and the limitations of the fixed fee. And then we'll be talking about the next study. What we've sort of found, what's important to put into context is looking at these custody records. We were looking 2019 to 2021. Now, over the last 10 years, the number of children brought into custody has fallen by 2/3. That's an amazing feat, so we need to put that into context. It's increased by 7% last year, and we're hearing anecdotally that some forces, the number of arrests of children has gone up by 50%. So new police chief constables are coming into new areas, it's driving up arrest rates, so we really need to see what's happening. Once arrested, and when a child gets taken into detention, or when anybody gets taken into detention, we find an almost rubber stamping of the decision to detain. So in less than 1% of cases are the police saying, no, we're not going to bring them in. Looking at legal advice, this is the good news story. 45% of adults and children in 2009 have requested a lawyer. It's now up to 80%. And so that's excellent news. But we're finding that once again, 10 to 13-year-olds are the least likely of all age groups, or for more children this time, to have a lawyer, even though they're the most vulnerable. Probably have mum or dad as the appropriate adult, don't understand the importance of legal advice, most vulnerable group, and getting worse outcomes than their older peers who have a lawyer. What we're finding in police custody, and I think this is really important, they're being held, children are being held on average for 11 hours and 36 minutes. Just need to stop and think about how long that is. 14 hours for adults. In 2009, it was for adults and children 9 hours. It's an extremely long time, and I'll say more about that. 54% of children are held overnight in police custody. Now, bearing in mind during UN Convention and other rights, custody should be used as a last resort and for the shortest possible time. Not seeing it in practice. So let's turn to the case outcomes, what's actually going on. This again, I think, is really, really important. I'm going to start with 2009 data. Now, bearing in mind many more children were brought into custody then. About 1/3 had no further action, 42% were charged, and 26% received an out-of-court disposal. Don't forget, we've now got far fewer children. They're being dealt with for more serious offences, and we've got 61% having no further action taken. The numbers charged has reduced by half, and the number of out-of-court disposals has similarly reduced dramatically. So all these cases, 11 and a half hours, and nothing actually happens. I think it's true to say that the increased involvement of lawyers has probably added to that. Lawyers are more likely to advise a child client to say no comment. They know that a child's likely to start talking. They'll probably say about this, say about that. They'll incriminate themselves. So they're protecting their child, their client. So they're spending over 11 hours in custody. No action is being taken in the majority of cases. And the process for some of the police officers I've spoken to is being seen as the punishment. So it's not a presumption of innocence, it's a presumption of guilt. So it raises questions about what type of cases are coming into police custody. If it was up to me, I'd limit it to indictable-only cases and perhaps complex cases, but that would be the limit. I just thought I'd share this with you. This is outcomes. I hope you can see it okay. About when legal advice was requested, we don't know whether it was received or not, but you can see here that more children receive an NFA, no further action, when they have a lawyer. About the same proportion that are charged. Far fewer receive an out-of-court disposal. And I think this is important because I think if a lawyer was able to be involved earlier on, they'd be able to get a child out of custody, they'd be able to argue more for diversion, but the way the process is at the moment, that just doesn't happen. So what's happening from that child's perspective? I went into cells, they wouldn't really let me take them out into an interview room, which I wanted just for a break, but I went into the cells, so pleased to see me, even the big age gap. Oh, I haven't seen anybody, sit down, talk to me. They're being held in a cell for all these hours with no one to talk to. The detention officer will come along in 30 minutes, every 30 minutes, are you all right, do you want something to eat, and that's it. Nothing really to distract them, they can't have a mobile phone, they don't know what time it is, and they describe it as dehumanising. Now, if we take 11 and a half hours of the average that they're in detention, the police interview comes towards the end, so we're guessing that it's about 9 or 10 hours that they're being held in a cell before they're interviewed. Half of our 32 young people didn't eat food. 6 of them had been held for over 15 hours. That doesn't put them in their best state to give their best evidence. Most of the children see the process as part of their punishment. And with that high proportion of NFAs, no further action, it means those children are getting no help and support at a time where they've come to police notice, often because things are going on in their lives. For the children, custody is seen as harsh and punitive. It fosters resentment with the police and undermines trust in the police. It actually helps to increase reoffending rather than to prevent offending, which should be the primary aim of the system. These are some of the comments that we received from the young people. I feel like a caged animal. You can read them there. I literally went insane. You feel like you're treated like an adult already. I want to share this with you because the sense I get, children have no agency. You come into a process, you go around that process, you come off, you get the risk assessment, you go into your cell, you come out for an interview. You don't really have any rights that you can exercise at that time. So one of our young people did say, this is like a punishment, but we're still human. And that really struck me. We need to humanise what goes on in these police cells. Vulnerabilities. This is the vulnerabilities that the custody records pick up on. We think this is very much an underestimate. Children will say to me, well, I've been suicidal, but I'm not going to tell the police, they'll keep me for longer. And so, and then a child say, well, I'm not really much wrong with me. And then you find out from a parent that they're being tested for autism. So it's an underestimate. And some of them are unaware of their health problems. The risk assessment is about how safe they are being held in a cell. It's not about their health and well-being. And if it was, perhaps we could find out what's going on and help the children rather than punish them. 18 of our 32 case studies reported neurodivergent or mental health issues. That's 56%, far higher than the police are looking at there. So when we talked to the young people, 18 out of our 32 children didn't understand their legal rights. I'm not so bothered about that if they've got a lawyer. 29 out of 32 did have a lawyer. How can we explain some of those rights? You need somebody to be there for them. What's really important here is the first contact that they have. And in only 4 cases prior to the police interview did a child have a contact with their lawyer. And in the other 25 cases, the first contact was at that police interview. Remember, this is 9 or 10 hours. So they get booked into custody right early on. Would you like a lawyer? Yes, please. And then 10, 11 hours, and then they first see their lawyer. This is also happening with their appropriate adult. They have to have an appropriate adult. Mum and dad may come down at the beginning, an agency appropriate adult may do samples, but they're not engaging, they're not available, they're not there to talk to them. So again, they're coming down for the police interview. And I just want to bear in mind that under PACE, children have a fundamental right to speak to their lawyer and their appropriate adult in private at any time, including over the phone, but this rarely happens in practice. As a researcher in police custody trying to facilitate those conversations, it's not happening. The police might be worried about parents, are they involved? The appropriate adult service, they're saying, well, come down for the interview. It is difficult to get lawyers involved. The fixed fee is a real problem. 2008, the introduction of the fixed fee, don't pay for the time waiting around. How can a lawyer come down at the time they're detained and then they're not dealt with for 11 hours later? So a lot of lawyers are saying, just tell me when it's the interview. I'm not going to speak to my client beforehand. And this is the reality. But that then leaves that child without advice and assistance that right at the very beginning could have got that child out of custody and into perhaps mental health or social services. So what we find within the system, we've got a separate youth court, we have separate things for children in the health service, we have a mandatory requirement for appropriate adult, but apart from that, that's it if you're a child. You're held in the same type of cells, interviewed in the same way, held for a bit shorter, but that's about it. No specialist training required of the police or the lawyers when dealing with the children. But it is important to say that the police are being left on their own to cope with children in custody. They have limited contact with social services and youth justice services. I've had children being brought in for domestic arguments. They come in, one lad, 17-year-old, 1 o'clock in the morning, he'd broken a plate. So he's detained at 1 o'clock in the morning because they can't get hold of social services. But then you're drawn into this adversarial process and you're not going to be released till you've been interviewed. Mum's not going to make a complaint, but we're going to hold you. Another lad came in as the suspect. In the morning, they found out that he's the victim of family violence, but he still held him for 18 hours to try and sort out what was happening because they wanted to interview him. Where are social services? Where are these other agencies that's got a statutory responsibility to take care of the children? The police would happily hand over, and this is an issue for government to sort out. Without that, children are being criminalised and detained unnecessarily. So what we're finding is a justice approach being dominant, but it's not focused on identifying and meeting the needs of the child. I think that's why I hand over.
Thank you so much. Well, I'll just pick up from where Vicky left off, really, and invite you to think about, as lawyers, how one might think about these problems in the police station in terms of your own practice, potentially, and in terms of the broader rights framework. As you can imagine, since I was involved in Unfitness to Plead, I'm particularly interested in the concept of effective participation. And I kind of urge upon the room that this is a really key issue to think about. If, as Vicky's research and custody record analysis as it demonstrates, children aren't finding themselves in court, that's a good thing. But as a result, the whole adjudication phase has really moved backwards. There we are. Has moved backwards into the police station. The vast majority of children are being dealt with without recourse to the criminal courts at all, without recourse to the sorts of remedies that those of us who practice in the criminal courts can use for children in terms of excluding the interview. The court doesn't have any purchase on issues around should they ever have their detention authorised, and rarely gets to consider conditions and experiences at trial. And so I wanted to just invite you quickly to have a think about that concept of effective participation. We're starting to understand a little more about what we think that might mean in the courts themselves. But the European Court has said quite plainly that effective participation begins in the investigative stage and at the police station. And that must be right, mustn't it? Those of you who attend police stations or do criminal trials will know that often the die is cast at that point. And the child's engagement with their rights is really, really key. So the case of Panowitz and Cyprus set out quite plainly that this right exists from those first stages. And really, I've put in the kind of boxes on the right-hand side, the sort of features that the court has said this right to participate effectively requires of the authorities who deal with those children. And it's informed by observations made by the UN Committee on the Rights of the Child, which also feed into this area of jurisprudence, one might say. And so those three key issues are ensuring adjustments, so adjustments that minimise the child's situational adversity, reducing those feelings of intimidation and inhibition, and taking account of their inherent need for special care and protection, care that accommodates their special capacities and their needs. Well, if we think about what Vicky's research has identified, in no way, sadly, are those feelings of intimidation and inhibition addressed in the custody phase. However nice the custody sergeant may try to be, and some of them do their very, very best. The reality is that it is a situation with a significant power differential. It is harsh, it is adult, and it can be very frightening. Are there special needs taken care of? Well, you've seen some of the comments of the children from Vicky's research and from my own research, very similar experiences. No adjustment for their needs in the very adult cells in which they're kept. What about fostering appreciation of their legal jeopardy or their options as regards the allegation and their defence rights? Well, particularly for a child who isn't represented, they will receive no information pre-interview about the allegation that they face. The police are required by their guidance specifically not to indulge in such things. They will have heard their grounds of arrest and they will go into interview without any further information necessarily. For those who are represented, we know that of course there'll be pre-interview disclosure with their legal rep. But as Vicky's research points out, that consultation will be 9-10 hours into detention. And children told me quite clearly, I'm just not up to it by then. I don't want to talk to them. Actually, I think their arrival 10 hours later might be the reason why I've been stuck in here. So I don't want to talk to them. I'm not ready to give them my account, and I'm afraid about what will happen to it. Are they independent? Who's going to hear about it? Will they force me to grasp? There are so many issues for them that engagement is problematic. Do they understand their defence rights? Well, interestingly, Vicky's research reveals how variably the caution is explained to a child in police interview. Children talking to me displayed significant misconceptions about what the caution means, but unhelpfully, interestingly again, they were often very confident that they fully understood what the caution meant, making it very difficult for lawyers to identify that problem and to support it. Understandably, a lot of lawyers advise no comment. In the interview, is there that enabling of understanding? Again, we're looking for a kind of general level of comprehension with assistance as they require it. But what we do know is that unlike ABE interviewing and the training that's required for police officers interviewing children as witnesses, children being interviewed as suspects can be interviewed by an officer with no training at all in eliciting their evidence. Pick one, the very lowest level is all that's required. Am I running over? I think I might be. And so children described to me very clearly feeling that they had been tricked, had their words twisted, those sorts of coercive tactics that we think the peace interviewing model should be ruling out. Vicky's seen some more positive interviewing and active listening going on, but it would be entirely unsurprising if there are officers who are engaging in that sort of interviewing style because of their lack of training. So there are real issues around the fairness, one might think, of interviewing a child after 9-10 hours in a cell and then providing no specialist adjustment, no specialist training for the individual who is interviewing them. And the reality, as Vicky has really strikingly set out, is that the whole process, in effect, becomes entirely unproductive. So not only have they had a terrible time in the cell, But the whole purpose of police custody is meant to be securing reliable evidence, interviewing under caution. But what we have is often no comment for understandable reasons, or that risk of unreliable evidence. So these are, you'll appreciate, pseudonyms. These come from an earlier piece of research that I did. So Logan on the left is expressing that concern. You know, I'm feeling pressurised. You feel so pressurised, you might have to lie and say, yeah, fair enough, I did do it, just to get it over with, because they'll just keep pressurising you. Now, that's an extreme position, but the reality is that evidence given under these conditions and without that effective participation is liable to be unreliable. But at the same time, it significantly alienates children and their families. And Tom's comment on the right-hand side is not uncommon amongst the children that I've spoken to. You know, I've had such a terrible time in police custody. I wouldn't want to go to the police for help. I don't think they're safe for me. So what are we doing? So I'm lucky enough to work with Vicky in this next stage of the project. We're piloting the recommendations that come from her earlier Nuffield study in a second Nuffield funded study, which is a practical one, trying to bring some of these recommendations, child first approaches, into police custody. So as a very quick ready reckoner, we want to ensure that children are only finding themselves in custody if absolutely necessary. Key is the shorter pace clock. The 24 hours for everyone shouldn't be the case for children, and so we're working on piloting a 12-hour clock. A presumption of legal advice, looking again at the appropriate adult safeguard, a different model for interviewing child suspects, specialist training for everyone involved with children at that stage, particularly specialist youth lawyers, and better data. It shouldn't be up to academics like Vicky to struggle every 10 years to try and obtain the data. The government should be producing reliable, disaggregated data for us so that we can hold them to account. So thank you so much. Thank you.
Thank you so much to Miranda and Vicky. The question from Anna, which was on the Q&A, is there information about the race of those detained, a demographic breakdown, including socioeconomic factors, geography? I think the answer is...
We do have ethnicity, we have age, we don't have socioeconomic status, and because we're having to treat the data anonymously, it's difficult, and some forces are insisting that even with the data management, we're not identifying them. So 8 forces this time. We did 4 forces last time. I'm the only person to have done this. And I was with the Legal Services Commission back then, so that was part of government, and that was difficult enough. And I just thought that with these electronic records, it's the only way to know whether somebody's got a lawyer. I kept saying to the Ministry of Justice, you need this data, you need this information. You don't even know whether they've requested it, you need to know if they've received it. So I am working with, we're working with the Ministry of Justice now to say this is key data for you, and just to say it's ridiculous that it's owned by individual police forces and the Home Office can get that data. They're getting some data, but they're not asking for outcomes, and they didn't ask for legal advice. You know, they should be held to account. But we do have ethnicity. We have done modelling. Ethnicity comes out as a really important issue. I think basically if you need to go into what happens when somebody gets stopped in the street. I think that's where you're going to find the discrimination going on, and that comes in, and there's no checks and balances that stop, and so therefore over 50% of the youth custody population are BAME and a high proportion of black young people. And there's no challenges. So we have got the data, but nobody's got the data on what actually happens on the street and when they begin to get those initial criminal sanctions, and that's what we need.
Thank you, Vicky. So we are going to thank Miranda and Vicky, who are going to seamlessly leave, and we're going to be joined by our next panel. So thank you again for sticking. And I'm going to hand over to Irena.
Thank you very much, Kate, and thank you to our first 2 speakers. Absolutely fascinating, if rather depressing, but I feel maybe a theme of this afternoon. So I'm absolutely delighted to play a very small part in introducing a very distinguished panel who will be talking to you about children's rights, particularly in the immigration and the asylum system. And we have three speakers, one of whom is joining us online because sadly Nicola Braganza is not feeling too well, but she will still grace us with her expertise, for which we're very grateful. And all I'm going to do to make time for the speakers is to introduce them. Firstly, we have Stephanie Harrison KC, who is a very dear colleague of mine and an absolutely brilliant lawyer. She is the Joint Head of Chambers of Garden Court. She needs very little introduction, but here goes. She is a leading practitioner in the field of both public and immigration and asylum law, has over 30 years of experience in the most complex of cases. She specialises in claims of torture, human trafficking and other forms of serious violence, including sex and gender-based violence. She frequently appears in the highest courts and in landmark cases concerning the interpretation and application of the Refugee Convention and other interrelated international human rights. She is unsurprisingly ranked as in band 1 for immigration in Chambers and Partners, and it's an absolute pleasure to introduce her to you this afternoon. What I'm going to do is introduce everybody so you don't have to hear from me in snippets. Our next speaker, and I'm delighted to introduce her and meet her today for the first time, is Whitney Hard, who works for the Quorum Legal Centre in the Community Care Team, who are an organisation who do fantastic and groundbreaking work. She joined Quorum Children's Legal Centre in 2019 and then qualified as a solicitor. Her caseload involves both public and community care law. She undertakes all types of challenges under the Children Act. She particularly focuses on representing children and young people who are or have been detained in custody, including those on remand, victims of trafficking, and particularly county lines. So it's my absolute pleasure to introduce to you Whitney Hard. And last but not least, joining us online is Nicola Braganza KC, who is a colleague at Garden Court and fearless and brilliant lawyer. She is, again, unsurprisingly recognised as a leading barrister specialising in equality and discrimination law, public law and human rights. She has a broad practice which spans the area of immigration, detention, immigration and asylum, community care, education and employment, particularly on discrimination claims. She has vast experience in bringing complex and large-scale challenges against the state, including civil claims for damages on behalf of those individuals who have been subject to detention and in group litigation. She regularly represents highly vulnerable adults and children, including victims of trafficking and modern slavery. So, without further ado, I'll hand over to Stephanie Harrison KC.
I'm going to just do a very brief introduction because myself and Whitney are going to talk about one particular issue, but from two different perspectives. And the issue that we're going to speak about is the increasing prevalence of children going through the criminal justice system, but who have been assessed as adults. And that's in the context of immigration decisions that were taken on arrival and in the context of criminal prosecutions for people arriving on small boats. So obviously a highly contentious issue. The numbers of people overall being prosecuted for what is an offence created first in 2021 of illegally arriving So arriving without prior entry clearance. The numbers of people who've been prosecuted for that significantly increased in 2022, and Whitney will explain what she and others were able to identify about one of the consequences for obviously a highly vulnerable group of young people, which is those who are claimed to be under 18 on arrival, but the Home Office, through a very cursory assessment of their physical and physical appearance and their demeanour, actually says, we don't believe you're 18, you're under 18, you're over 18. And they go through the whole criminal justice system treated as adults. So however inadequate and limited the protections are for children within the process that we heard today in the police station, those disputed children experience none of those protections at all, because nobody is even recognising that they are under 18 and have special needs that need to be addressed. So that's the context, and Whitney is going to talk about it from the frontline experience of how those children in those cases came to across her desk, and then I'm going to follow up with a outline of the legal issues that arise and give you an example of a case where we have successfully so far not completed the litigation, challenge this process of the way in which the Home Office itself refers for prosecution children who are disputed children whose age is in dispute. I'll hand over to Whitney.
Hi everyone, and thanks for inviting me here today. And yes, it is a very important and complex and quite novel issue that we were seeing. Essentially, usually when a young person is age assessed by the Home Office, they will be given paperwork, they'll be in the community, someone will notice at some point that they have to be referred to the local authority for a lawful age assessment. That isn't happening in these cases. So what is happening is the Home Office date of birth is being taken as their correct date of birth, and it's often being seen as a mistake of their claimed date of birth. So for example, we have actually seen the IS-97, which is the document confirming their age and that they're liable for detention, being reissued with the Home Office date of birth, or having their claimed date of birth just crossed out. So it almost looks like a mistake. They get to the police station, often they're not actually asked what their date of birth is. And this is in the context of the majority or all of the clients that we have been representing that we're aware of are Black African. They are subject to adultification bias, they're subject to the discrimination in the courts anyway, but there's a whole added layer of the language. They're recently arrived, they know nothing at all about the process whatsoever. They may not actually always understand the interpreter from the start, so immediately they're put in an extremely hostile environment. We have seen records where some of the age disputed children have actually been able or given the opportunity to raise that their date of birth is incorrect, that their date of birth makes them a child, and they've described being ridiculed, bullied by the police officers, and then just saying, yeah, that's not your age. I don't know why you're saying that. Like, isn't that so funny? They're being immediately, not always now, but I'll come on to that a bit later about the change in actually what's happening. But at the start of when all of these cases started coming to our attention, they were immediately being detained. And that detention was in men's prisons with adults. There was no, again, notification to the prison officers that they could potentially be children, that they were age disputed. So they're being put from one hostile environment into another extremely hostile environment. The majority of them, all of them, have trafficking indicators, have experienced detention in Libya. They're extremely vulnerable. This isn't getting picked up. The culture, anyway, of being in a prison, particularly for someone who is age disputed and recently arrived to the country, absolutely is put all on them to self-refer and to raise themselves that they have experienced trafficking or detention, which isn't going to happen. They're extremely scared, frightened, and there is a general culture of not saying anything in prisons anyway, especially adult prisons, where the more longer serving adult prisoners are essentially, taking them under their wing and giving them advice, which they're taking immediately. They're not saying anything. The first time we're picking up on it is in instructions if we get referred that client, and then we go and see them the access to them is extremely limited because of delays in getting appointments. And then we have a very short amount of time with them to go through essentially a journey, their situation, how they know their age, getting instructions to be able to actually work on their cases. We did issue judicial review proceedings regarding a safeguarding challenge. So for children, age-disputed children who are detained in adult immigration detention centres, there's a very clear policy about how these young people should be treated in a way that safeguards their welfare and well-being. There isn't one that exists for prisons and adult prisons. It's a very new issue, and that's partly the problem. We were trying to make these arguments. Unfortunately, it became academic very quickly. The time of sentences for these young people varies. Often they've been in an adult prison so long they just want to get out, so they will accept to be sentenced as an adult so they can be released, and then it's unpacked later. But there is, again, like there's a brief mention to it in the Modern Slavery Guidance for Prison Staff about referring to the local authority. But again, it's just not getting picked up by these prison officers, and it's only if a solicitor gets involved. And Stephanie's going to talk more about this later, but there's an issue with where the courts are able to make a decision on age, whether that be interim or they decide that's the whole proceedings and they're concluded. The consequence of that is a duality of processes for these young people. So we had one young person who was in local authority care, sentenced as an adult, in local authority care on licence, waiting for an age assessment. Into a fight, which what happens, you're in a place with loads of other young people, was recalled back to an adult prison for 28 days. Advice was sought from a specialist prison lawyer who said there's nothing we can do, the time's too short, we won't even get to the parole board in time for it to make a difference, and then was released straight back into care, awaiting for the age assessment. So he's being treated as a child in one aspect and then not in another. We've also seen judges being very frustrated at how long age assessments take. They take a long time. It's really important that the young people are safeguarded during that process. It's extremely traumatizing for them and very triggering, and it has to be done in line with their needs. There's no needs-led process. The judges are furious, some of them, that the court time's being delayed, it's being wasted. I can just make this decision on their age now, let's just get it over and done with. Being very frustrated. We have also seen other cases which we have not directly been involved in, but an independent social worker report to determine age was commissioned, and the independent social worker said, yeah, I think this young person is a child, here's all the reasons why. It was presented back to the court. The CPS challenged this. It's unclear on what grounds they weren't accepting the report, and then have now said they're going to go and get a dental report. Obviously, various institutions, British Association of Social Work, Royal College of Physicians, British Medical Association have all come out and said that these reports are inherently unreliable, they are unethical, and so essentially it's unclear what arguments are going to be made in that case for that young person, but it's unclear what weight is going to be attributed to independent social worker reports if that is the case that's happening. Usually the courts will just take an age assessment from a local authority as being lawful, whether or not a community care lawyer has been able to look at it and actually say, yes, this is merchant compliant, this is a lawful assessment. We've got one case at the moment where fortunately the young person has not ever been in prison yet, and that is hopefully the process that we're hoping for. His case has been adjourned to the youth court and he's in local authority care on bail waiting for an age assessment, and essentially that is in line with the needs and the safeguarding the process that should be happening, and Stephanie can take you through all of the law behind that.
Yes, so as you can see, this is a really challenging situation, and where you do have disputed children going through the system, it represents a complete systemic failure to identify that child at the outset and to make sure that the decisions to charge them or to refer them for prosecution, for charging, and the way that they're dealt with in the criminal justice system are all on false basis, because they're all treated as if they are adults and having been conclusively determined as adults by the initial Home Office age assessment. And in terms of starting with the Home Office, I think I'm going to be able to. Yeah, so we'll know that the Home Office's powers to detain a child, a person who they accept to be a child, are very limited, and they can only hold a child for a maximum period of 24 hours. The key issue, however, is if the age is disputed, then those time limits don't apply at all. And there is a situation whereby the initial age assessment that the Home Office makes, based on their policy, which was upheld as lawful by the Supreme Court in a case called BF Eritrea, we'll have the reference later, that upheld a policy whereby it was lawful for the Home Office to make an age assessment for the purpose of detaining people simply on the basis of whether or not their physical appearance and their demeanour showed that they were significantly, very significantly over 18. But it still rested upon a lay officer looking at the person, interviewing them in an interview that can take a matter of a very short space of time through an interpreter, usually on the telephone, and then having made this judgment call that you're 18 or over. And one of the important things that happened in the Supreme Court was that the policy used to say that you needed to be, your physical appearance or demeanour needed to strongly suggest that you were over 25. So obviously, if you go and buy a beer, or if you want to buy some alcohol, you'll be asked for your you'll be asked for your proof of your age to buy a bottle of beer. If you don't look over 25, they're going to want to have proof. That is not the case if you're going to find yourself detained in immigration detention. The Supreme Court said that it isn't appropriate. The Home Office don't need to only identify cases where the person is over 25 to be confident that they are not under 18. The question is, are they over 18? So you're having to make a distinction on the basis of physical appearance and demeanour between someone who's 17 and someone who's 18 and 1 day, and it's literally impossible to do so. But that is the law, or the policy position that has been taken following the case of BF Eritrea. There's a bizarre situation where if you subsequently establish that you are under 18, that will, as a matter of fact, render your detention unlawful. It's a precedent fact question, and if you subsequently get an age assessment that establishes that you're in fact under 18, you have been falsely imprisoned. However, that isn't the criteria of an objective question of fact when it comes to detention. So what has happened is that the whatever protections there previously were, since the case of BF Eritrea, very significant numbers of children or potential children have been held in immigration detention when they couldn't have been. And then in the context of the increased use of the power to prosecute for these two offences, Section 24 and Section 25, these are the two offences introduced to criminalise essentially claiming asylum. Because it used to be that if so long as you arrived in the United Kingdom and indicated on arrival that you were going to claim asylum, the fact that you arrived illegally without prior permission didn't render what you did unlawful. This legislation was introduced to end that protection for the right at least to seek asylum, so long as you didn't enter illegally. You know, there also were protections under the Refugee Convention, but as long as you arrived and said, I'm here claiming asylum, no criminal offence. That changed. And as a result of that, we've seen this increased number of the combination of factors leading to an increased number of disputed children finding themselves in the criminal justice system. And it's right to recognise that that's a particular concern when we look at those who may be potential victims of trafficking, because they also are not being picked up for the reasons that were explained. And that's important because, as with many other offences, your age is critically important as to whether or not you might have committed the offence, and that's especially so if you are a child and maybe a victim of human trafficking, because the threshold is very different. But that protection in the legislation, you'll see the different offences that there are for children. It doesn't require you to have any question of compulsion. So for a child to be in a situation exploitation. Libya is one example, but even the regime by which you came to travel across the UK may involve trafficking for a child, because they're involved in a situation of exploitation by the smugglers or traffickers who bring them here. But none of those protections are being afforded to these children. And obviously we all know that the Code for Crown Prosecutors has particular protections for children. It's supposed to be a very different regime. Age is a critical importance, not just to whether you've committed the offence, you may well have done, but there are still very powerful public interest reasons why, even if you are potentially guilty of the offence, you nevertheless shouldn't be prosecuted. That code is not being applied to this category of child either. So once they get into the court, then it is the court's responsibility to inquire into the age of the child. And all the guidance and the bench books that I've set out here that you can see recognises that age is obviously a very important matter, and there is a positive duty on the court to resolve this question. The onus isn't on the defendant, but again, that is not operating to protect these children. That obligation of inquiry is particularly important in trafficking cases. The case of RO established that. Proper inquiries need to be made, and that would apply more generally, but that's been recognised, particularly in the trafficking context. Again, that isn't being protected. Key guidance from the CPS about where you do have refugee and asylum seeking children is that where there is an issue about that, the proceedings should be adjourned in order for a Merton compliant age assessment to take place. And that's a proper age assessment undertaken by social services, a holistic assessment that will take days, even sometimes weeks to do, rather than the 5 minutes at the port that the Home Office have engaged in it. That's the policy position. But again, that is not happening in all of these cases and on a systematic basis. In the criminal justice system, a visual assessment of physical appearance is not a lawful and adequate basis for assessing the age of a disputed child. That was set out in 2 cases that I've given you the reference to, RL and RM. But as we've seen, because of the way in which the system is operating at the moment, children are going through the system based upon an immigration officer's assessment of physical appearance. So that's the problem. What's the solution? And it's right that this is a new situation, contemporaneously is a new situation, but actually it's not novel in the sense that it already happened before. So before the Home Office changed their policy as long ago now as 2005 on age assessment, there was extensive litigation that I was involved with Pat Murphy solicitors to establish that the previous policy was unlawful. And as a result of that, large numbers of children were recognised to have been unlawfully detained, particularly in the fast-track system in Oakington. But we also had one client, Mr. HBH, who had been prosecuted for offence of forgery offence. And we were able to establish that his conviction was unlawful, and in particular, that the Home Office's policy of referring for prosecution based on physical appearance and demeanour was unlawful. And you'll see that the central ruling of Mr. Justice Keith, as he was in that indented paragraph, that the methodology prior to the 30th of November of treating as adults asylum applicants who claim to be under 18 years of age for the purpose of deciding whether to prosecute and or refer them for prosecution for an immigration offence on the basis that an immigration officer considered by way of his own brief assessment the applicant's appearance and or demeanour strongly suggested they were over 18 was unlawful. So that's what we established in 2009. That is obviously now gone by the wayside. The Home Office rely upon the case of BF Eritrea to now say, well, our policy on age assessment is lawful. So it is lawful for us to use physical appearance and demeanour as a basis for prosecution. That issue we have sought to litigate in one of the cases that were brought to our attention by Quorum. And we have been able to succeed in that young person's criminal conviction being overturned. He had pleaded guilty on the first appearance, which the research shows that that's generally what happens. the pressures to plead guilty are enormous, and that's what they do on their first appearance. He had pleaded guilty, but he had spent almost 8 months in prison whilst all of this process was going on. By the time the issue of his age assessment was raised, the judge who was going to sentence him was saying, well, we can carry on with this process, but if I can deal with it today, I can release you because you've served more than enough time. Going rate for this offence is 12 months. So he took that. Now, the same judge, when we made the application out of time to overturn his conviction, made it clear that he was not at all happy with what had happened and that he was wanting to reopen the case, and the CPS conceded. Now, on one view, that's excellent for the individual, but we have a judicial review, which the Home Office are now, and the CPS, against the both of them, the Home Office and the CPS, saying is academic. We are hoping that we can keep that case alive because there is a claim for damages. So if you do have cases like this, you may not find them when you're in the process, in the criminal justice process. If children come to you, you have an age assessment and they're established later to be children and they have been through this process, then there are remedies that you can have, both in terms of overturning their convictions, but also in bringing claims for damages. There's false imprisonment claims at the outset as far as the Home Office are concerned, but there are also Article 5 claims that can be brought for conviction, for periods of time that are spent within the criminal justice system when they're detained. And there's case law, which I think the two cases there I won't go into at the moment, but they do establish that where a prosecution goes on for too long, because that they haven't, that there's indication that of evidence that the person shouldn't be prosecuted, then that can give rise to liability on the part of the CPS or the director. Similarly, if they haven't taken into account relevant considerations and done what they're supposed to do, that can also give rise to illegality, sounding in damages under Article 5. So we're hoping we can keep our JR alive to establish again that it's unlawful for the Home Office to refer children, disputed children, on the basis of these cursory assessments. But if not, it will have to be a civil action. The aim is to get these cases at the beginning. That needs us to liaise with the duty solicitors. It's very difficult to get them to engage in this kind of complex argument, but that's got to be the priority, so that we do not have a situation where you're unravelling a traumatic, damaging experience. This young person has suffered extreme deterioration in his mental health. There's an Article 3 claim as well, because the impact of this experience of adult detention has been so severe. And so we really do need to get to the position that no disputed child is referred for prosecution unless and until they've had a Merton compliant age assessment. That was certainly the intention of what was supposed to happen after 2009 and was happening until this very recent changes and increase in use of power to prosecute as part of the ending the small boats strategy.
Well, thank you very much. And Stephanie, that was absolutely fascinating, and also shining a bit of hope onto this difficult and complex subject. Can I invite Nicola to join us if she's ready? And she's going to be talking to us about the provisions of the Illegal Migration Act. Hello, Nicola.
Hello, everyone. I'm really, really sorry not to be there. So takeaway points. Power to detain is provided for within the IMA sections 11 and 12. It's all to be found in the regulations, which is what the section set out, but there's no sign of the regulations at the moment. So we're no wiser in terms of the detail of detention. So the official government line is that this is all about not incentivizing people to bring or send children. There is in fact no evidence about this to make out the Home Office's point, the government's point. And in fact, the government recognises the harm that detention causes. Again, don't in any way make out the justification for detention. So we're no wiser as a result of it. And so the point, what I want to flag up is when these regulations eventually do come through, look out to see what provision is made as to the length of detention, the place of detention, provisions within detention, to also have in mind challenges to be brought in respect to the regulations. Right, I'm now going to move on. So this is what's being said, is the thinking behind the detention. And as I say, it's not laid out in anything that we do have. There are 3 particular assessments carried out specifically on the provisions. And what is said by the Prime Minister in this session for the Parliamentary Liaison Committee in defending the detention of children is just not in any way substantiated. So what he said is the policy objective is not to detain. It's important we don't inadvertently create a policy that incentivizes. So that's the thinking behind it. But as I say, beyond that assertion, there's nothing else to make it out, whether it's actually down to gaining votes and pushing the political agenda is more likely to be the case with the stop the boat policy. And then he went out to set out, you increase the likelihood of bringing children here. They make very dangerous crossings. I don't think anyone would want to see that. That's not good for children. So the policy should and must apply to families. Right, we can then look at families differently. As I said, you create an incentive. So that's the only thing that they've come up, this supposed incentive and the pull factor. Right, so the current position is, and Steph spoke to this, in terms of unaccompanied children may only be detained in short-term holding facilities and in no other place, either except transfer or while being taken in custody for the purposes of, and then that's set out in paragraph 18.3. And the policy, most recently updated 28th of September 23, sets out that detention has got to be for 24 hours. And even if the child is removed, again, the length of detention no longer than 24 hours in accordance with the directions. And the policy specifically sets out the Section 55 duty to have regard and take into account that the Home Office continue on case details of individuals detained. The policy could be promptly amended to avoid the detention of children. And also what the policy says, and there's a change in the language of the Act, there should only be detention in very exceptional circumstances, the shortest possible time, and immigration removal centres are a no-go. Unaccompanied children are not to be held there. And again, highlighting that the decision-making process must be informed by the duty under Section 5. And this is also important because look out to see whether this is set out within these regulations that we're awaiting in any policies and guidance to supplementing the regulations. The reviewing officers must have received training in children's issues. So what does this Act say? The Act says, to summarise, pretty much in all circumstances, you can detain an individual. That's all set out at 11.2, where the immigration officer suspects that the person meets the 4 conditions. So it's in as wide as terms as you could imagine. He may detain pending a decision. He or she suspects the Secretary of State Home Department has a duty to make arrangements. She may detain pending a decision. If there is such a duty, pending removal. If the 4 conditions are met, but there's no duty to remove. So in all those situations, the individual can be detained, the child can be detained. And just to remind you, look to Section 2 for what those conditions are. Section 2CD provides for the further scenarios in which detention can be carried out. And then coming to unaccompanied children, as to unaccompanied children, the duty does not require the Secretary of State to make arrangements for the removal. Secretary of State may make arrangements. Power subsection 2 may be exercised only for the purpose of reunion or where removal to a country, state, or where the person has not made a protection claim or an HR claim, or as may be specified in these regulations. That's 3D. And then unaccompanied child is defined in subsection 5. Importantly, and this is where this is the source for the regulations, 2H sets out that the powers in 2C, the powers of detention may be exercised in respect of an unaccompanied child only in circumstances specified in regulations. Those regulations may specify the time limits that apply. They may confer a discretion. And then again, very broadly, 2K may make different provisions for different purposes. And then 2M, person of any age detained under 2C anywhere that a Secretary of State considers appropriate. That's what the relevant provision sets out, the statutory section. Following on from that, the power to grant bail is heavily restricted in respect of an unaccompanied minor. Section 13B, the end of the period of 8 days beginning with the date on which the person is detained, their detention. And there's no challenge. The challenge is now limited to a writ of habeas corpus. There's no challenge in that time, in that first initial period, and that's provided for in section 13.4. Section 14 disapplies, very gravely, the duty on the Secretary of State to consult the Independent Family Returns Panel. And the explanatory notes provide no further information, detail, understanding, or insight at all as to why this is the case. All that is set out in the explanatory notes, if you go to paragraph 111, is the reasoning for and the importance of the Independent Family Returns Panel in terms of providing advice on safeguarding and welfare, making recommendations on how best to safeguard and promote. And then there's just one line saying, and this section disapplies that, very concerningly. So where is this incentivizing from? What is there by way of surrounding documents or evidence to be relied on to make out this justification for potentially widening, or actually widening? Without the regulations, we don't know the extent to which they're further widened. But what is the basis for it? There are 3 assessments, and I'll whiz through those because I'm conscious of time. There's the Child Rights Impact Assessment. So if you're bringing a challenge, go to that, because you will see there references made to this incentive, but there's no basis for the incentive. The incentive goes back to the first slide I showed you about what Rishi Sunak was saying as to why the provisions have been brought in. The Child Rights Impact Assessment goes on to say where a decision is made to remove an unaccompanied child under 18, detention will be for the shortest possible time. So we know that much, in appropriate detention facilities with relevant support provisions. And then also refers to the UNCRC and what is directly relevant to detention, reminding again within this assessment that the Home Secretary has a duty under section 55. So again, no more insight on the incentive there. Finally, what's also set out, again, what's being repeated is detention powers are only to be exercised in very limited circumstances. So the very exceptional has gone, but the shortest possible time is there, and the very limited circumstances. Statistics are set out within the Child Rights Impact Assessment. It gives you some idea of the numbers involved and, if detained, what we're concerned with. So 2022, over 5,000 asylum applications from unaccompanied asylum seeking children, 39% increase on the number prior to COVID. So you have the Child Rights Assessment. There's the Equality Impact Assessment, which again, that sets out the bill provides unaccompanied children may only be detained for the purposes prescribed in the regulations, which we are awaiting, as I say. It allows Secretary of State to make regulations specifying time limits to be placed on the detention for the purpose of removal if required. And then, unhelpfully, the view that the bill should have a deterrent effect. So really, when Sunak was giving evidence defending it, this really was no more than an assertion, because their own Equalities Act assessment sets out that the evidence just isn't there. It's designed to safeguard the most vulnerable, and any differential impact is described as justified and proportionate, but in fact there's no forensic basis at all available to justify it. So the evidence, what about the impact assessment? That's the final of the 3 assessments. Well, here we then have it. The bill is a novel and untested scheme, and it's therefore uncertain what level of deterrence. So it's all just effectively hot air. This includes elements such as detention, caseworking, judicial and third country capacity constraints. I'll try and wrap up in the next minute or so. The Children's Commissioner has said that she is deeply concerned about the impact the relaxation of rules around detention. The impact of the Act that it will have on children is still not fully understood. I remain unconvinced it's possible for the Act to be implemented in a way that is compatible. What is the impact of detention on children? Well, the Joint Child Detention Briefing House of Lords report set out that the Home Office itself published guidance stating a period of detention can have a significant and negative impact on a child's mental or physical health. Previous research evidenced the long-lasting damage detention does to children's lives, both lone children and those with their families. So it is quite astounding that so far we know no more than I've taken you to as to what is intended to supplement those statutory sections. I end where I started with how it is defended. So is it a pull factor? and the briefing set out, continuing to have limits on child detention will not increase the number of children coming to the UK on small boats. Once routine child detention was ended in 2011, there was no proportional increase in children claiming asylum. We have not seen that this is likely to happen, nor that it would justify detaining children. So there is no justification for this new line. So next step, await the regulations. Again, we're working in the dark pretty much at the moment because we don't know what they're going to provide for and how they're going to vary from the current provisions of 24 hours and short-term holding facilities. Section 55 obviously has to inform all decisions to detain. The decision makers must have regard to the guidance, and every child matters, as set out in ZH Tanzania. And the failure to take account of best interests of a child can render the decision to detain unlawful. That's the case of Abdullahi. So what if in the unfortunate situation of being instructed and getting a child out of detention, and in terms of what the regulations might say, what to look to, it is the detention carried out for the very shortest period. Is there demonstrable, i.e. evidence of Section 55 consideration compliance? Where is the regard, the provision for welfare, health, safety and education? Has there been training of the immigration officer decision makers? Is there provision within the regulations and within your individual case, right to prompt access to legal and other appropriate assistance being raised or being flagged up? And then finally, what I've set out there in terms of challenges, Article 3 challenges, there's the case of pop-up from France, detention of children in inappropriate accommodation can potentially engage Article 3. Article 5 is the case of Canada-Ratnam and Belgium, concerning the conditions of mother and 3 children closed transit centres. And also what I flag up is whether there is also an Article 14 discrimination challenge in respect of Flemenos discrimination, which is requiring children specifically to be treated differently by reason of their vulnerability as children. And then finally, I've set out the case of AN, where the practice of detaining children for the purpose of conducting so-called illegal entry interviews in breach of policy. So all very, very right challenge. And obviously, UNHCR's clearest view is that children should not be detained. And I've set that out. And there can't be any dispute with that. And that is where, thank you very much for bearing with me. And that's where I end my section. Thank you, everybody.
Thank you very much, Nicola. Thank you, Nicola. You have our full sympathies for doing this when you're ill, and also our thanks. It's no mean feat. So thank you very much for joining us. I'll just read out a couple of comments that have come in from those joining us online. One is from Fiona Anderson, who says, I'm an independent social worker, and it's so important that social workers are commissioned to ensure the rights of the child are upheld and to ensure that the local authority are not acting oppressively and biased towards the child. I think we all agree with that. It's really important to get the expertise as soon as possible. It's the practicality of that I think may be difficult to achieve. Debbie Allen says, this is all exciting and very appalling. I share your sentiments, Debbie. She asked, what is the penalty for unlawful detention?
Well, obviously, if it's a damages claim, so that if the Home Office have unlawfully detained and or the CPS, it will, if you've got a false imprisonment claim, then the damages are in principle likely to be higher than the awards under the Article 5 of the ECHR, but there is case law that suggests that they ought to be parallel, that tortious damages should be the ECHR damages should be the same, and that ECHR damages, if you also had an Article 3 or 8 aspect of the detention claim, they are separate from and distinct from the false imprisonment claim. It's not double recovery, you're compensating for a different kind of violation. That's the case of Mr. Justice Green with the War Boys litigation at first instance was really, really helpful case on the distinctions between ECHR damages and false imprisonment. So the state will have to pay. There's no other penalty. They don't seem paying up after they've committed illegal acts, doesn't seem to change it, which is what you would hope is going to happen, but we seek to go round in a circle. No other penalties arise that I can think of.
Are there any questions from the room? Yes, I see an arm at the back.
My question is around access to the NRM for victims or potential victims of trafficking. The Legal Migration Act and landscape is still obviously really unclear, and I appreciate there's not a lot of precedence behind this, but if there are any sort of trends or any information or inputs you have around access to the NRM, particularly for victims, potential victims of trafficking, and those who are non-British.
Essentially, it's really important to get them in touch with a first responder. The police officers are first responders, but generally they're not the best, and also they're not spending that much time with them, and there are other issues. Usually we would say the local authorities, I mean, if they're children especially, or even age-disputed children, I would say local authority is the best first responder in that sense, because they are talking to them anyway in the context of an age assessment, so they should be getting lots of information, they should be picking up those trafficking indicators. We are seeing that they are generally picking them up and they are referring them in. Otherwise, the Salvation Army and making it clear to them what those indicators are for those vulnerable young people. I mean, in prisons, they also do have a duty to refer to the NRM, but again, given the context of the environments in the prison, it's less common, I would say, in that sense. And I think it will probably get worse with the Illegal Migration Act because of the impediment of that access. But
I think one of the things that's coming out of looking at the cases that are coming through where there's been prosecutions, but it will probably happen in any caseload that you have, is what did the Home Office do at the outset? So they used to conduct screening interviews. I don't say they've abandoned it, but they do not do it systematically. And in some circumstances, particularly when people are in Madston, they were not conducting screening interviews. So therefore, if you don't screen, you don't get the indicators of trafficking, and they're very likely to arise in a large number of cases because of all the numbers of people who are coming through Libya, where it's well recognised that may well have involved a period of modern slavery in conditions of exploitation, etc. Obviously, there's other kinds of trafficking indicators that will come, but if you don't ask the question, then you never get the indicator. And that is part of both their operational practices, and also we have to recognise, as the Illegal Migration Act now makes clear, this government does not want to give effect to the obligations under the Domestic Statutory Scheme and Article 4. They just do not. They have said in terms that they think it's a mechanism that's used for abuse. So I think that you can institutionally avoid having to make referrals because you don't ask the questions in the first place. And then what we saw in the cases when they go to the police station, the police are not asking those questions either. They focus just upon the criminal offence, and they are not alive at all to the fact that there is a real issue about the whole arrangement and the way in people come in small boats. And I have seen expert evidence that looked at the position certainly for children, and that would in itself constitute exploitation and may in itself be an act of trafficking rather than smuggling. Obviously, there's a distinction between the two, but that is not being addressed. And one of the things that they do is that they tend to prosecute both for Section 24, which is the coming without prior entry clearance, but also Section 25, which is assisting, and it's a much more serious offence, and it's a life imprisonment penalty if you are convicted of it. But one of the things that we've seen on the evidence is that people pay less if they agree to steer the boat. And trafficking experts also say that kind of exploitation, you're putting those people in a particular additionally risky situation, more serious criminal offending, that can be an element of exploitation and coercion that might give rise to trafficking. But of course, none of that is being considered at all within the system because they're all seen as smuggling and themselves criminalised without ever recognising that those people coming on small boats may also be victims themselves. So there's a real massive, it's a very significant deficit in the system by design and also by default. On that note.
I think we've all deserved tea or coffee. Before I let you go, can I just ask you again to thank our panellists who've been absolutely brilliant.
In which they considered whether the use of the inherent jurisdiction to authorise the deprivation of liberty of a child was Article 5 compliant. And Amanda also has a particular interest in immigration-related children cases, forced marriage, protection orders, and FGM and modern slavery. I'm going to hand you over firstly to Hannah, who is going to talk about Section 25 orders and deprivation of liberty orders.
Thank you very much, James, and thank you very much for you all staying for this latter part of the afternoon. Just in terms of moving on to slide 3, just to say what the presentation will cover. So James has already outlined that I'm going to give a sort of broad brush approach to Section 25, the DoLS jurisdiction, and then a little bit around the new DoLS court and some judicial commentary on the issues that many of us will be aware of out there, and touch on issues with placements. I was going to have, we were hoping to have Maggie Jones join us, who's a very experienced barrister in chambers, but unfortunately she wasn't able to come this evening. So that section I'll just keep very short. So the next slide, I just wanted to put this quote up. It's a quote from Mr. Justice MacDonald involving a 16-year-old girl who was at high risk of serious self-harm or suicide in a case where there were no suitable secure placements to meet her complex needs, but in that case the court had to approve an unregulated placement, and I'll be talking more about that later. But one of the reasons I put it up there, because we're here at a conference about children's rights, and I think it's important. It is important because I think as family lawyers often we don't see our work as about children's rights, and I think in a lot of work we do actually children's rights is really the focus of what we do, but particularly in this group where we're looking at Section 25 orders, looking at DoLS orders, it really is very much the coalface of children's rights. And I think so we do need to consider as family lawyers that we really are children's rights lawyers as well. The next slide, just a little bit of law. Section 25, the criteria for using accommodation that restricts a child's liberty, and you can see there what that section provides, and I'm going to say a bit more than that. You can read that there. That they must have a history of absconding. I'm changing he today. They have a history of absconding, likely to abscond from any other description about accommodation. And if they abscond, they are likely to suffer significant harm, or if they're kept in any other description of accommodation, they're likely to injure themselves or other persons. So that's Section 25(1), and I think it's also important, the first part of that section is that it is a child who is being looked after. So you have to have a child who is being looked after, or if there is a simultaneous application for an interim care order or Section 20. And then I've just cited Section 25(4) there, which is about the maximum period. On to the next slide, just to say a little bit more about the criteria. So I've said already that the child has to be a looked after child, and the court doesn't have to find both A and B satisfied before making an order. You saw the two parts to that. Either of those is sufficient. So you've got the absconding, or you've got the likelihood of injuring themselves. In terms of evidence, there needs to be a clear record of the facts, and there needs to be sworn evidence to that effect. So in relation to Section 25, the welfare principle doesn't apply, but the court can't abdicate all responsibility. Now, one thing I'd say about this, because this came up in a case I was doing the other day, is that if you have, although the welfare principle of Section 1 of the Children Act doesn't directly apply in Section 25 cases, when it does apply is if the court has not yet made an interim care order and the local authority is applying for one and needs one, in order to get their Section 25 placement. So in that case, the court will have to look at Section 1, will have to look at best interests in its totality when it's making that decision, and look at placement in the same way that it would in relation to any application for an interim care order. And I'll say a little bit more about that in the end and about that case. And so clearly Article 5, a secure accommodation order, is a deprivation of liberty, and it is a deprivation of liberty within Article 5. Appropriate court, I just say a little bit about that because I know some of you will be working within the criminal justice field. And so I've just made that comment there about where a child's been remanded to local authority accommodation by a youth court, then the application by the local authority should be made to the youth court rather than the family court. But the work I do is in the family court, and that's where the applications are obviously now to the DoLS court, or in the case of Section 25 within proceedings. So I was just going to say here a little bit also about the attendance of children at hearings. I think this is an interesting issue when you're looking at this issue in the context of children's rights and having their voice heard. So the court can allow a child who's the subject of the application to attend the court. Courts have traditionally taken quite a view that it may be harmful for the child and should only permit if it's in the child's best interest. I think this has evolved. I think experience shows, and Beverley may have more to say about this, but my experience shows that the courts are much more open for children attending, whether that be, and since COVID, that's often remote. There's often a lot of practical barriers in the way of children attending a court. For example, if they're already in their placement, and that may well be a long way from the court concerned, travelling down. But it is really important for the child to feel engaged and have their voice heard. And if that's whether by them being brought to court, which is often better, but for some children, young people, it's not better, and actually talking to them remotely and then being able to join remotely can be a really good option. But it's to be clear, there's no presumption against a child attending a hearing, and really the court has to look at, and everyone has to look at the issues that you would in any case, sort of age and level of understanding. There often will be an older child that you're looking at, the strength of the child's feelings. If the child is very strongly opposing, and that would again be a very good reason for a child to be involved. Child's emotional, psychological issues. And I mean, in my list I've got child's behaviour, but I've done cases where, yes, you could probably say the child's behaviour is quite disruptive. It doesn't mean the child shouldn't be there, actually, because actually them feeling part and having some control over what's going on, feeling like their voice is being heard and hearing why decisions are being made, I think can be really, really helpful to those children that are involved. So I think courts are more open to it at all levels, and I think all of us acting in these cases need to push for children to be involved, like I say, whether that's remotely or otherwise. I think that's probably what we'll say on that one. So moving on to deprivation of liberty orders. So one of the things to say on this is that's important here is that it's the same structure in many ways of Section 25, so the terms should be treated as applying to the same effect if you're applying under the inherent jurisdiction. And as we all know, the inherent jurisdiction is basically being used much more often now when there's no places available in secure children's homes. So a DoLS order authorises the deprivation of a child's liberty in settings where it's not otherwise registered to do so. And of course, in many cases, this is basically because there are no secure placements, no places for the children to go, and the courts are having to authorise places under the inherent jurisdiction and use deprivation of liberty orders in many different ways. And we all see the restrictions being used, sometimes just in order to get a child to a placement, where in fact there won't be, they're not intending to use many of the restrictions once they're at the placement. They're hoping that once they get to the placement, the child will settle and will not need any deprivations of liberty, but need some of those restrictions, supervision, 2 or 3 people, perhaps some authorisation of some force to enable the child to get to that placement. And then a variety of different restrictions and different placements that are used. Then at the then in terms of the placements itself, and we'll come on to some of those placements that the courts are authorising. Just on the next section, and I'm not going to say too much about this because I know Beverley, I'm quoting Beverley's work here. So I've just got one slide here about the DoLS Court, the formal Deprivation of Liberty Court, which was launched formally in July 2022. And all new applications are now issued in Royal Courts of Justice. My experience is often, in fact, as it says in that last paragraph of the topic, that cases return to circuit, which means where applications are issued at the RCJ, they are largely heard in the court where proceedings are ongoing, if there are existing care proceedings, which there often will be. I'm not going to say anything about that data, but you can see there is a fairly horrifying number of applications, and we'll say more about that. There's also, on the next slide, James, on shortage of placements, you've done it, thank you very much. What's also horrifying is the serious shortage of regulated secure placements for children and young people, which results in courts being left frequently with no option to make but to make deprivation of liberty orders authorising children or young people placement in unregulated placements. Now, I'm just going to say very briefly here, and perhaps slightly controversially, and I know there's some people here from local authorities, but what I can say is I think, we all think that placements should be regulated, and ideally there should be those placements that are the right placement for children, and nobody's going to say otherwise. But there are occasionally, it seems to me, times when it seems that there are placements which are better for children. They're not always secure accommodation, which is the right placement for children. It's not always the registered placement that are right for children. In these cases, clearly, and we've got the example here of G. This is the 2020 case. And this was. I'm actually going to deal with Re S first because that came first in time, and that was a decision of Mr. Justice Cobb, and that was about reviewing a deprivation of liberty order for a 15-year-old girl. She was already the subject of an interim care order. She had a history of absconding from placements and self-harm, and she was currently living during these proceedings as the only young person in a holiday cottage in North Yorkshire. And she was living with and was being supervised day to day by 3 adult members of staff. So I don't think anybody would have looked at that and thought that that was a suitable placement for this young person. And the placement was unregistered and therefore unregulated by Ofsted. And at the time of the hearing, 188 days passed without a suitable registered placement having been found. This was a case where they weren't able to, they simply weren't able to find a placement. And what the court said and what Cobb said was that the local authority was doing its best for her. But it was just not a situation which met her multiple needs, being for therapy, education, stability and security. And this was a case where, in order to raise awareness of the plight of Tess, the judgment in this case was going to be sent to the rather short-lived Mr. Williamson at that time, the Secretary of State for Education, the Children's Commissioner, and at the time Minister for Children, saying regulation of our children's homes offers an essential safeguard for delivering appropriate care for our young people. And so that's just one example where there's a shortage of placements. The next one, UG, again similar, and that one, this one of those horrifying cases that often reaches the media, where a 16-year-old had been detained under the Mental Health Act, vulnerable young person with multifaceted difficulties and a high risk of serious self-harm. And he was in urgent need, in this particular case, of a secure placement. But at that point, no placement in the whole was available in the whole of the UK. And the only option for her was to place her in an unregulated placement under the auspices of an order authorising the deprivation of her liberty. And again, there's another case, this time McDonald J, saying by reason of her high complex needs, she was a child who fell through the gaps that existed between secure accommodation, regulated accommodation and detention under mental health legislation, and just lamenting again the fact that there simply hadn't been any change, saying the brutal reality facing the court was that if she's not deprived of her liberty in an unregulated placement, there was an unacceptable risk that she would end her own life or cause herself and possibly others very serious physical harm. So we can see the horrifying situation being faced here by those acting in these cases, by local authorities and by judges who are being faced really with decisions that nobody would want to be making. So, and this is not something, and I know Beverley will talk about this, but this is something that's not new, it's not gone away. On the next slide, I've given this really, Mumby, I think, is not one to mince his words, and he certainly didn't in his case, saying it is a disgrace to any country. Attentions to civilization, compassion, and their one thing of basic human decency. So that was back in 2017, and where are we in 2023? We have the now President Justice McFarlane, similarly in slightly more measured language, should we say, facing exactly the same problems in trying to find a placement for X in this case. Again, a child, a 15-year-old who'd suffered significant trauma and whose complex needs meant they require restrictions on their liberty to keep them safe. And again, what the President in this case was emphasising was that this was not a one-off facing this this child. This was, he said, one being shared by 70 or so others for whom places were being sought that day. And I think in that case there was, I think one of the interesting things about it was that the Secretary of State for Education had actually put in a response, a skeleton argument, and so the court recognised that, not that it solved the problem, but the Secretary of State's position was to acknowledge that the system was palpably not working and had not been working for many years. So the judge saying for the first time, it recorded an acceptance from the Secretary of State that nationally there were significant problems with the availability of sufficient placements, which requires the collective action by the government, because local authorities simply don't have those placements, and there is not the placements to meet the needs of these children with such complex needs. But just briefly on President's guidance, this is from September 2023, because in 2019 there had been guidance which we were all following in relation to DoLS applications, which set out what the court was required to do if after approve a deprivation of liberty order in a placement. There's been some slight rowing back from that guidance, which was from 2019, which was to ensure that steps are immediately taken by those operating units to apply for Ofsted registration where it was not in place, and would require the courts to do almost a sort of monitoring role to at least keep people updated. That's not entirely gone with this new guidance, but it what the President has said in it is it's not the court's role to do that monitoring. It's the court's role to exercise its inherent jurisdiction to ensure any deprivation of liberty is not itself unlawful, and that's the extent of the court's powers, and the court's role should not go beyond those powers. There is a paragraph that says this does not mean that there are not really great benefits for the child or young person to be placed in a registered rather than an unregistered placement. And I appreciate what I haven't done is gone into detail around the differences between registered and unregistered, regulated, unregulated. And I think Amanda Jones will say a little bit more about that, but I can't necessarily come back to it. So, and what it also says, so if proposed placement is unregistered, the court should inquire as to why. So we do come back to this point about best interest, considers an unregistered placement in the best interest of the child. And then this is my last slide, I think. And I just acknowledge at the top there, because I think it is, and I think as all working in this field recognise and acknowledge that local authorities themselves are working under really considerable pressures here. It isn't when we come to court that there's no placement. Sometimes, and obviously as lawyers, we have to scrutinise absolutely what the local authority are doing, but often you come to court and you can see that local authorities have been searching, and their teams, their placement teams have been searching and have been inquiring. And it can take months to find suitable placements, and it is a dispiriting, and it must be dispiriting for the people, social workers, the people who are trying to find the best place for children. And that does mean then for children themselves, they're left in unsuitable placements, and we see this in the work that we do. Either they're left in homes with relatives where their needs are not being met, their complex needs are not being met, they're absconding, they're going missing. There's nobody really able to exercise parental responsibility. Or they are in placements already which are just not suitable and not meeting their needs because they're away from their families. There's no education facilities on site, there's no therapy start on site. And these things will go on for months and months without those optimum placements being available, that we all those gold dust places that have education, that have the therapy, that have the missing the word for it, but the holistic approach to children that we really want with these children of complex needs. And we have those extremely vulnerable children that we've mentioned from McDonald's case there, where you've got extreme mental health issues, but you also have children who have got into the, they've started absconding, they're going missing, they don't have those sort of needs, they're not self-harming, they're not doing that, but they need to be in education, they're out of education, they're absconding, they're running county lines, they're at risk of sexual exploitation, and they need to be in a safe place where they get the right support to get their needs. So you've got sort of those two sort of groups, and you need to find the right place for those two different groups of children. They're not necessarily the same sort of places. It's not a one-size-fits-all for children. But what isn't meeting their needs is that taking always. This is a difficult one, I think, because often there's an attitude now which is, again, I'll be interested to hear what others say about this, where taking them children a long way from their families and their community is the right thing, because it takes them away from the influences that they have. And I think this is something we really need to grapple with. Is that better for them or not? And I think really this is why courts have to really grapple with individual children's situations. And again, and
recently, I think judges can be quite, I think they can be sensible about this. I had a case a few weeks ago where the placement was well away from the family home. It was a 28-day placement, so the child would have stayed there for 28 days, and then there was no real plan. But this was the only placement in about 3 or 4 months of looking that had become available. So the local authority were desperate to have this child moved there. But the judge said, actually, no, when you balance out those factors of moving him from everything he knows, he's got some education down there, even if where he is far, far from ideal and we've got significant harm, there has to be a balance between what that placement is providing. And again, it's one of these, I don't know whether some of you have seen these places when you've spoken to children, but some of these placements can be hugely dispiriting, and they can be, they barely fit the name of a children's home because they are just a residential house and they are often the only child in it, and with a few adults in it. It's a bare room with maybe a television in it, and yes, the situation the child is in at the moment may not be ideal, but what is it you're moving? And it really needs a lot of scrutiny into what that placement is that you're going to deprive their liberty of and move them to. So that's where I say courts will refuse applications where it can't be shown that the placement is in the best interest proportionate. And that, although I've said best interest doesn't apply, if there is no interim care order, if the child isn't looked after, then they will need to show Section 1 welfare and best interest for the child.
Thank you very much, Hannah. That was very informative. We're now going to hear from Beverley.
I'm using arrow. Okay. Thank you for inviting me to come and present this afternoon, and thank you, Hannah. That was absolutely brilliant. Thank you so much, and to listen to the early presentations. Just want to give my respect to all the lawyers out there. I'm not a lawyer, I'm a social worker, but I just want to give respect for all the hard work you're doing to protect our children's rights, because it's a very difficult time at the moment for all of us, but particularly our young people. So I'm just going to give you a little bit of a flavour of the evidence and the research we've been doing around the deprivations of liberties. We've had some of you may have seen our research, I hope you have, but we had the opportunity to be invited into the DoLS courts when it was set up in July 22 by the President, and to access the data and to publish monthly reports around numbers and demographics, but also get a sense of how we were finding out about the children and who are these children, because it was just an unbelievable phenomenon to discover that we'd gone from something like a number of 220 to 300 in 2020 when the Children's Commission of England looked at DoLS, to 495 when we first looked at it back in May 2022. Just want to start with a story, which is Shane's story. So I'm just going to read this to you, and I don't need to help you to situate yourself where children are, because I can see that and feel the passion already. But Shane is 15. He was removed from his birth parents as a baby and adopted when he was a year old. Concerns about his behaviour started to escalate when he was 8 years old, following an incident that led to him being temporarily excluded from school. His adoptive parents increasingly struggled with his behaviour, and he came into care when he was 11. In the last 4 years, he has lived in 8 different places, including 2 placements with different foster carers and 6 different residential placements. He can be verbally and physically aggressive, has assaulted staff and damages property. He has self-harmed, taken overdoses of medication, and has said he wants to kill himself. He smokes cannabis and drinks alcohol. He's been out of education for 6 months. He does not have any formal diagnoses, but the local authority are seeking reassessment for ADHD. He was settled for several months in one placement with a dole in force until an incident when he attacked staff and set fire to furniture, at which point the placement gave notice. The local authority struggled to find a new placement for Shane and is proposing to place him in a rental flat under a dole order while it continues to search for a replacement. Restrictions sought are 3-to-1 supervision, removal of items that he could use to harm himself, monitoring throughout the night, doors and windows locked. He will not be permitted to leave the placement, and physical restraint will be used as a last resort. He will be looked after by carers from an agency he has never met before. I'm sure, Hannah, you would recognise that, that these are the sort of typical presentations that we find. This is a composite of lots of young people we read about in the last year. But just to remember, this is a 14-year-old young person with a real history of disruption to his relationships and the care that he's received. And this is where we end with this picture of him, isolated on a 3-to-1 supervision. So, as Anna had on her beautiful slide, which was nice to see, in our last 12 months of our research, which was July 22 to 23, we obviously identified that there had been actually over 1,200 children subject to applications to Department of Liberty. There were 1,589 applications, and these applications relate to actually 1,249 individual children. The applications are mainly made by local authorities, with a small number made by hospital or mental health trusts, counted 18. And this, I think, Hannah, goes to your picture around section 25, which was, in my days as social worker, what we were using in these cases. We see a significant reduction in use of secure accommodation orders in these children's cases. It's actually been 10 times more applications under the DoLS order between July 22 and March 23 to secure accommodation applications. And of course, applications don't mean placements, because you're fighting for any time in a week. There are 70, 80 requests for maybe one bed in secure accommodation. So we've got 1,051. I mean, there's a clear story here. There's been a significant reduction in the availability of secure accommodation. I think we now have, with 2 new coming on board, 19 secure accommodation units. When I was in practice in the 2000, there was over 108. Massive reduction in the availability of these placements. Have to raise that there's also questions about their effectiveness and whether they did much use, but they were available. You could, work with something. There was something for social workers and assist them to turn to. Consequently, there's always seen a reduction in Tier 4 beds for different reasons, but again, that's squeezed the system. Some regional differences in DoLS, but we know it's a nationwide problem. Just to draw your attention, for those of you in London, 27 applications per 100,000. We saw 40 per 100,000 in the northwest. The East England has the lowest, or only 15 applications per 100,000 children, but it's a nationwide story. Most children are 15 years old, but some are under 13. Small number, 9.3, but they are under 13. And I will just stop on that for a moment, because Hannah, you might be able to help me here, but the under 13-year-olds in a secure accommodation is a slightly different approach to how we manage those children, because when I was in practice, you had to get permission of the Secretary of State to secure those children. You had to write to him every week to let him know how they were doing. So the government took a keen interest in the well-being of those groups of children. And here we have 9.3% under 13. We found some 9-year-olds in our case study, some 9-year-olds under a DoLS order, and no extra provision for them, no special plans for them. Real concern. Boys and girls affected equally in terms of gender, so roughly 50-50. Small number of children we saw presenting as non-binary or transgender, and that will change in different contexts in different parts of the country, but we found a small minority presenting with a non-binary or transgender narrative. We don't have good data on ethnicity, because unfortunately that little application form doesn't answer the ethnicity of children, so we have to dig into the statement from the local authority practitioner. And sadly, we still have social workers not talking about culture or ethnicity in the reporting children's needs and their applications. So lots of missing data, about 45% of missing data. The data that we did have, where it was available, suggested that children from mixed and black ethnic groups were overrepresented compared to the general population. and children from mixed ethnic groups and backgrounds are also overrepresented compared to children in the care population. But we can't say that this is representative, but it would fit in with the picture that we see disparities in the numbers of children who come into care proceedings, and we see disparities in terms of children who are subsequently cared for and looked after in terms of the care population. So again, there is something here that we need to be very mindful of. And when I speak to different practitioners in different parts of the country, they tell me, oh yeah, we've got a lot of this going on. There's a lot of issues here about what's happening in terms of the kind of children, young men, young black males who may be getting subject to DoLS interventions and other cases where they're not seen. So again, we've got to be mindful of disparity and racial disparities that might be occurring. Children often experience ongoing trauma and adversity. This won't be a surprise to us, but we've got to remember the majority of these children are already in the care of the local authority. They're already looked after. They've had long-term involvement with the local authority. When we looked at 208 applications between July and August of 22, only 10 children and the families have recently come to the attention of the local authority. And as we said, 96% were already in the care of the local authority. And the index point seems to be 2 years into the care, and then we're hitting this crisis point. Something is going very wrong for our young people of complex needs who are entering the care system. We're not getting there. We're not meeting their needs. Children experiencing frequent disruption and instability. Again, over half the children had experienced breakdown of multiple placements. Some had moved as many as 10 times in the period leading to the DoLS application. Can you imagine moving 10 times as a child? You know, the trauma we feel when we have to move home once or twice in our lives with our children, and how our children really get into a state of anxiety about leaving friends behind and moving to a new area. We're fortunate, we've got a relatively stable way of managing these disruptions, but for these children it's just incredible disruption. There's no stability, and there's no prospect of something called relational stability, you know, the idea that you can trust the adults caring for you. And that's a fundamental for any effective therapeutic intervention at all in their lives, is that they've got to have an opportunity to be able to trust an adult around them. Frequent exposure to childhood adversity and trauma. And this was mentioned in at least 62% of the cases that we reviewed, but we know that it's likely to be higher than this. And again, children have multiple complex needs. In most cases, we saw multiple concerns that led to the application, included the child's behaviour, classic risk to others or to themselves, mental health or emotional difficulties or self-harming. Some of the children had physical or learning disabilities. Others were at risk of criminal or sexual exploitation, and over a quarter had a diagnosis along the spectrums, and 14% nearly ADHD. But the important thing to recognise is that children had multiples of these needs. They weren't just one category. They would be ASD, but also be a risk of self-harm, and also be a risk around mental health, anxiety, depression, so multiple presentations. And this is why we see in the design of our health system, just can't meet the needs of these young people because they don't fit easily down particular pathways of healthcare, and our system is really organised down the pathways of care. I don't know if anybody's ever looked at their local NHS delivery models, but there are pathways all over the place, and if you don't fit on that one or that one, you fall through little cracks. So broadly 3 groups of children we found. Those with children with learning and physical disabilities needing support and supervision, about 25% of cases. These children with very complex needs, often seen as response to past and ongoing trauma. That was the majority. And then we had another group of for cases that were clearly children experiencing that external intrafamilial risk factors and being placed due to their vulnerabilities at risk of exploitation. And then finding themselves in a world where they'd lost connections, parents beyond parental control, as it were, and the system was putting them into the DoLS place. And I agree with you, Hannah, there's a whole group of young people that don't need to be put into the DoLS place if we get it right for them. They don't need to be there. What happens to these children? So we did a legal sort of study of legal orders over 6 months. We looked at 113 cases. And these were issued in July and August 2022, so very early on our journey. We had a look at these 6 months later. And what we established was that the measures that come with adults, they're not short-term measures. 68% of the children were still subject to a dole order 6 months later. The restrictions are severe. Each child was subject to an average of 6 different types of restriction, including almost all cases constant supervision. Just think about being an adolescent and being under constant supervision. It makes my legs feel funny even saying it, because the idea that somebody's always watching you, especially the sort of naughty girl that I was. I wouldn't want anybody watching my eyes up to, well, then my neighbours would report it to my mother and she knew before we'd get home. But the use of restraint was permitted in 2/3 of cases. Restrictions are really relaxed over the study period. Am I okay for time? Yeah. Just checking. Yeah. The issue of restraint is a really important one I'd ask all lawyers to really think about. When you're in a registered children's home, they have to keep a restraint record, and you can access that restraint record. In unregistered accommodation, unless you are making that happen as a local authority, you don't get it. So we have really no idea what is happening to these people, and we should be making sure social workers down will find out what is happening around restraints and speaking to young people about restraints, because the young ones I've spoken to tell me about being put down on the floor being one of the biggest problems, the restraints being the big issue for them. So it's a major social work and legal issue for me, that issue of restraints. Over half the children were in unregistered provision, 53.8% placed at least one unregistered placement up to the end of December 2022. Children are living far away from home. The average distance that children were placed away from home while subject to a dole order was 56.3 miles away from home. And there is that debate, as Hannah raised, around when do we use geography as a way of maybe distancing from harm. And there may be some issues around exploitation cases. As part of a safety plan, the dole has been used effectively in that way. But this is not the case of most of those children aren't in that category. This is placement away wherever we can find anywhere. If that's what's going to happen, then so does the contact money and the support for a family or a friend to make sure that child is seen. You know, there needs to be more from local authorities to anything like that. Children and parents have limited opportunity to participate in proceedings. In our review, just 10 children, 9.6 children attended at least one hearing in their case. 5 children spoke directly to the judge before the hearing. 6 had written to the judge to share their views, and in that sense, they talked about why they were opposing the application. They were unhappy with the placement that they're in. They felt they had demonstrated the willingness to cooperate with the local authority, the social worker, where they need the doles. Opposition to particular restrictions. Obviously, everybody wants their phone. Not having your bloodies into it. Everybody wants a phone, particular generation. The vast majority, 88.5% of parents and carers were not legally represented at any dole case, and we've spoken to some parents who have been in that position who want to be actively engaged and found themselves in a whirlwind of hell, going into the High Court and trying to understand what's going on for their children, and nobody talking to them, no representation, very difficult experiences. And I'm not promoting stuff here, but just to point out that Family Rights Group have got a campaign around funding legal aid in these cases.
The problem is they don't get legal aid.
That's right, and that's all it's a campaign. That's all it's a campaign for that. And also the position of children. I don't think they're automatic parties either, are they? Children? No, are they now? No, they are. I don't want to go beyond my remit, but it's really important, that parents get the same. It's not that parents are not caring. They are very exhausted, but they want to be there for their children. Many of them do. So it's been a very difficult journey, but a very important journey for us in terms of, the President giving us permission to get this data out there and to inform all the system about what's going on. Out of this work, we started, and this was our chair who's about to retire, James Mumley, said, I want you to go out and really push this one. I want you to go further than you've ever gone before as an NFGO. Get away from just the data, get out into that system and start to talk to people about what needs to change. So we convened a sort of expert meeting with some of these eminent professors just to look at what are the kind of care what we need to be giving these children. And in an ideal world, we're already looking at the provision that they need. What would be the kind of care? I haven't put all of there's a whole document called Principles of Care. It's very nicely produced, but the key principles for children is they need stable, valued, trusted relationships. They need holistic assessment, formulation, which means it needs to be a multidisciplinary approach, and they need plans of interventions that are adaptive, because these children will give you different presentations as they go through their journeys of recovery. Today it could be depression, tomorrow it could be anxiety, the next day it could be outward directed aggression, following date could be self-harm. Their needs are very complex, and they need long-term support. Look at the average age. They're not going to recover very quickly. It's going to follow them all into their adult lives and beyond, and we need to think about those transitions and supports for them into adult life. We do need highly experienced multidisciplinary teams, and we obviously need to think about young people's agency and respect to young people, and that's one of the things that I'm very much focused on, is around young people and their agency, their voice. I've had the opportunity to speak to some of the justices around young people and voice, and they're trying their very best, but there is an issue here. I've spoken to children's guardians. Again, you know, it's limited what they can do, but there is a need to really think about these children and their agency and how we best promote their voice being heard in their court process. So conclusions, we know, as Hannah pointed out, we don't have suitable provision for many of these children with complex needs. It's a nationwide problem, but it won't be solved by local authorities allowing pop-up children's homes to happen in their areas where we've got these one child in a house and they're free to one supervision. That is not a response. The good news is that I think the President's commentary has been very useful, because we have now got the DFE and the NHS have created something called a task and finish group to look at the pathways for supporting young people with complex needs. And we're a member of that group, and we're hopefully doing some work around shaping what that group needs to look at. It can be the whole stakeholder council of all those people out there in provisions around therapeutic care. We're thinking about what can we create and do for these young people. One of the big parts of that is young people's voice in that sort of design and future design. So it's not immediate responding, but at least there was a recognition that it's about a systems change, because we need to have a position where the money that's in the NHS and the money that's in education and the money that's in care are pooled together to create the appropriate responsive provisions for young people. And this idea that we just kind of build a children's home and then buying somebody, it's not going to be sustainable for them. So that's it from me.
Thank you very much. So, Mike's.
I've got a couple of things to add. No,
go on.
I can see that there are a number of criminal justice practitioners in the audience, and my understanding, and they will all correct me if I'm wrong, is that young people involved in the justice system are routinely present at court and are fully involved, or as fully involved as possible, in the proceedings. And there is a complete difference in the family courts, which might occasionally in the child conflict or be involved, but the attitude is still really disgusting. And we have children's guardians and local authorities saying it's not in the child's best interest to go to court or to even know about the proceedings that the papers, they not allegations that are being made, and they do not participate at all. And what is happening in the DoLS court, you get a few young people to court, but they are routinely being told it's not in their best interest to come to court, or that they need to come to court because their guardian wants to be court. And there's a huge difference. And I'm sure that the people are horrified to hear us say, we ask the judge to let the child come to court. You can, some of us do, but the culture in the family courts is the children do this.
I mean, the culture, I recognise that picture, but the culture has been shifting over the years. It was very much like that. But also there is the issue regarding the representation model we have, which is the Kafka's guardian and the child's lawyer, and the Kafka's guardian taking a position which is, a Kafka's position, which is that anything that's unregistered is unlawful and transported. But what can we do? That tends to be the kind of position. But I think, for me, you're absolutely right. I think it's about agency and it's about control for young people. Although we have very young children, the majority of them are 15 plus. And the idea that they're not fully enabled to be participants in the decisions that are being made, the biggest decision around their liberty It's just appalling. Now, the good news is that the President has supported a couple of proposals we've got to look at how can we create a pathway for these older young people. Is there a way that we can create a pathway where they can have much more of their Article 12 enabled, as it were, to participate and to say what they think should be happening for them, alongside, obviously, the formal representation systems that are looking at. So a lot of the young people, we've actually this stage from CAFCAS, we hadn't got it yet, but a number of young people did split from their boundary. I don't know what they're on. Talk for me, you know. But yeah, you're absolutely right. I will say and I don't want to offend any criminal youth justice lawyers here, but it's very good research about young people. I am in court, but I haven't got a clue what's going on. There has been research around youth justice, so there's work and ongoing work to improve that as well. But you're absolutely right. The idea they're there, for big decisions to be made, and our young people and family are is definitely.
Thank you. So Amanda and I are going to discuss the issues around and potential legal challenges to this. There are a number of slides here. A number of them I'm going to skip because of the time we have, but we'll talk about more more topical, interesting aspects of it, because the slides are quite self-explanatory in respect to some of the regulations. Reminder that the 16 to 17-year-old regulations have now come in. They came in at the end of last month, which makes it local authorities can no longer place children in unregistered placements. They can have to now be registered placements, which is something that has been for under 16, something that's been in place for, I think now nearly 2 years. It has now been brought in that they have to be registered placements. That how and what will that change? I do not know. I think is my simple, straightforward simple answer to that. And I also think there will be a distinction put in respect of the distinction between a children's home and a supported accommodation, because under supported accommodation, as you'll see on the slides, which I won't be taking you necessarily to, is that there is a distinction. It's under supported accommodation, you can get Ofsted registered as a provider on 100 properties, for example, and only one or two of those properties ever need to be visited by Ofsted. Whilst if you're a children's home, every single provision you have, a children's home can have 1 to 4 buildings on a site, and that could be a children's home. I could be a provider of supported accommodation, and I could have properties all over the country, and I have one Ofsted register for all those properties. So whilst it appears to be a sensible and a better oversight from Ofsted and protecting our young people, let's wait and see how that will actually do.
I really agree with you, James. I take the same view. Having some of the necklace I have, I can tell you that there were people in Ofsted who've got their doubts as well, who are very worried, as regulators themselves about.
And Amanda was just going to touch, I think, on the first one, points of tension, and Amanda was just going to discuss this slide with you here.
Sure. So we're lawyers, and we're thinking about the potential for strategic litigation to deal with this problem. And it's important to remember that strategic litigation can work. We can remember the Baldwin case, the case about deprivation of liberty for under the old doctrine of necessity, was held to be inconsistent, incompatible with Article 5, and that led to the introduction of the deprivation of liberty safeguards, where everything has to go through a system prescribed by law in order to be compliant with Article 5. If there hadn't been the Baldwin case, there wouldn't have been those changes. That case drove the law. So one of the things that we're thinking about is looking at all the pieces of the puzzle that fit together, why we're in the situation we're in. I've just listed, obviously we've got we've heard very clearly today that the problems don't start when you're looking for secure placement. Problems start when children are a bit let down and their needs become much more complex than they otherwise have been, and then they can't find a placement. So just to go through the sorts of pieces of the puzzle that you need to be bearing in mind when you're looking at potential challenges, potential vulnerabilities in the system. First is the system of oversight, and we've just heard some pretty depressing news about the extent to which it's that the introduction of oversight of placements for 16 and 17-year-olds by Ofsted is going to be effective. Obviously, a lawyer going through those provisions and looking at the extent to which they're lawful and the extent to which they're effective might be looking at whether that form of that form of oversight would be sufficient to meet the requirements of Article 5 in a case where a supported accommodation placement was also the situation for deprivation of liberty. Of course, we draw a distinction between secure welfare placements under the law, deprivation of liberty, and deprivation of liberty plus children's so or supported accommodation. The other issue that we have to bear in mind is the sufficiency duty. And James is going to talk a little bit even about that, but we have a fundamental problem, a fundamental mismatch, because the duty to make sure there's sufficient accommodation available lies on local authorities. But the central government administers actually it's Hampshire County Council, but the allocation of those placements is done centrally. And so effectively, because of the marketisation, provision which is inherently unsuitable for marketisation, but part of that, the current situation is that local authorities cannot effectively control whether or not placements are going to be available in their area because those placements are filled nationally. Then there's the question of Article 5 and quality of law. Always, when we're looking at restricting or depriving a child or young person of their liberty in a looked after context, we're always mindful of the fact that deprivations of liberty have to be by way of a procedure prescribed by law and has to have sufficient oversight. And a procedure prescribed by law has two meanings in that context. It's not just a procedure prescribed by law by reference to the statute and regulations which apply or the common law. It's also in circumstances where that framework exists, but it's not being adhered to in a material respect. And then secondly, in addition, there's the issue of Article 3. We've already touched on the problem of complexity of need and the real problem of local authorities being expected to make quite complex provision for a young person for whom there's no Tier 4 family placement available within the NHS. And so that sort of additional complexity, that additional pinch point means that there may well be illegality around the unavailability of Tier 4 CAMS provision and the insistence on the process of the system on local authorities finding or putting together bespoke and often very difficult to arrange provision. I'll give you an example. If you've got a very urgent bespoke placement necessary, you might have a Tier 4 CAMS place will answer the question in the short term while the local authority puts together a bespoke arrangement. There is no Tier 4 CAMS placement available, so you have situations where local authorities are scrambling to find a property to make it, bring it up to code so that it can be registered, and then they have to staff it. And we've got a staffing problem, an endemic staffing problem in the care sector. So for all those reasons, you might even be looking at Article 3 cases where it's not been possible to make a child safe and to meet that child's needs, fundamental needs, such as to put them at risk of inhuman treatment. And then there's the sort of the other systemic problem about marketisation, that there's no step down, there's no identified provision which is bespoke for step down from secure back into less restrictive environments. And local authorities are left trying to design their own in the individual cases, and that's not workable. And then, as I think we've already discussed, we've got the problems of the adequacy of the new regulations and guidance in respect to the. So that's the sort of, globally, that's the sort of pinch points that you need to be thinking about, because it'll be lawyers. Judges have been raging about this situation. The Children's Commission has done a detailed report. The government's committed a load of reports. if there's going to be an engine of change, part of that can come from lawyers identifying the ways that pressure can be put on public authorities and the state to honour its obligations to young people. At that point, I'm just going to hand over to James.
As you say, you'll have the slides come out. So this has got the new regulations that have come out in respect of what accommodation is suitable for 16 to 17-year-olds. I've got my comments in respect of the issue in respect of Ofsted and whether in fact there's going to be any sort of better regulation of these placements and whether the children are going to get the outcomes that they need from these placements and whether this will actually make a change going forward. That just touching upon, as Amanda was saying, myself and Amanda, and you sitting here going, we're not blaming local authorities, it's not a local authority problem. All the judges are aware that there is the duty upon the local authorities, and this is the section of the Children Act that provides that duty. That you'll also see on this is that there's the statutory guidance, and having looked at it myself and trying to look in it, for example, in respect to secure accommodation, there's one passing comment in a document that is 37 pages long in respect of guidance towards local authorities and what their obligations are into obtaining secure accommodation. And when I found that it was more of a passing reference saying they have an obligation to find them. And the interesting thing, touching upon what Beverley was saying about the limited amount of it, currently I don't think there's one at all in London. And as far as I'm aware, I don't think there's one in I think it's the Midlands. There's no secure accommodation at all in those two areas at all. And as a provision that can provide secure accommodation, that is why their young people are going everywhere.
Again, we don't want to beat up local authorities because they're all salami slicing their limited resources. But just to give you a flavour, I mean, when you go to court and you argue about this stuff, when we argue about it in DT, Department of Education's starting position was, well, the sufficiency duty under statute as provided by Parliament lies on local authorities, and local authorities are stuck with that. And so the central government, and that's when these issues are canvassed in a legal environment, are very clear that for instance, the What Works for Children's Social Care report that was commissioned by the Department of Education reported that only 56% of local authorities had published a sufficiency strategy. That means that some local authorities have not made clear publicly how they plan to meet this duty. Now, local authorities are going to make themselves very vulnerable. I know that nobody in this room has any power over those kinds of decisions, and we wish we do, but it's true that it's only a matter of time. Either local authorities are going to be challenged for failure to meet and carry out sufficient inquiry in respect of the needs of the children in their area, or in the context of existing challenges to deprivation of liberty where they're being argued about, people are going to be running Article 5 again. They're going to be running Article 5 again on the basis that the framework isn't sufficiently prescribed by law. I'll come on in a minute when James goes further on to another reason why.
Yeah, and I'm going to, as you see, I've touched upon this central allocation in respect of, which is a unit managed by Hampshire but paid for by DFE. That is to be replaced by regional care cooperatives once the government decides to enact the statutory legislation to provide that. They're going to try and centralise it into a number of hubs, and whether that will work, time will tell. But I think we've heard on other talks, there's many things that have been advised and discussed, but it's currently was stuck with the government, has not been legislated, there's not the provision for it. I think that was from the care review that was about, in my understanding, about 3 years ago. I think so. The care review findings came out in inspectors, and we are still where we are, without a regional care cooperatives or central like hubs in respect of sorting out placements for young people. I'm going to, I think Amanda skipped the human rights gaps and risks slide and just deal with the very last, because I'm conscious that I think we are keeping people away from their refreshments before the next discussion. Unless, Amanda, you wanted to touch upon this one, because I think the other one.
I just want to say something about Article 5, and that is that Rought in the Supreme Court, the court didn't strike down the use of the inherent jurisdiction as being incompatible with Article 5. And one of the reasons they didn't do that is because of the President's guidance that was in existence at the time. The President's guidance placed the burden of overseeing the extent to which unregistered placements will comply with the registration process on the courts, in the DoLS court. Well, as Hannah pointed out earlier, that guidance has now changed. The guidance has now changed, and the President is now saying that's not your job, and the court should restrict its consideration and orders to its own functions. That's tantamount to an invitation to lawyers to run the Article 5 court again, because that oversight is no longer available. The courts aren't going to do it. It's a bit of a Mexican standoff with the government, because I think it right that certainly for the National DoLS Court and for the Family Division, the outcome of RETI was deeply unsatisfactory and certainly didn't resolve it. So I just think it's important that we're all alive to the fact that local authorities need to be alive to this as well. Article 5 is going to come rear its head again in cases where deprivation of liberty orders are being sought under the jurisdiction. So just here on other potential avenues of legal redress, once again, challenges to how provision is funded and secured, and the importance of the public lawyers of keeping an eye on what their local authorities do, not just in the individual case, but as regards their policies. Public law and human rights challenges to local authority decision making, again, that can arise in the context of a judicial review of a policy or public law decision they make, or it can arise in the context of an extant application where it would be its way through the Family Division. Human rights claims against the Secretary of State for Education may be in order if the a system being operated by the Secretary of State for Education, by the Department of Education, and the oversight by Ofsted is insufficient to meet the requirements of Article 5. Claims also against the Department of Health and NHS England as regards their financial gatekeeping of Tier 4 and other complex need provision for children and young people. They're aware of the problem. They keep commissioning reports about it and agreeing with them. But once again, it's going to be a question of committing serious resources to the issue. And the siloing. I mean, one of the things that really came across from what Beverley was saying is that the allocation of resources is sort of competitive. It's all in silos. Thanks very much. And I'm never going to take the midnight shift again. So and then there's the question of Section 11. Now, this is an underused provision of the 2004 Act. It's the cooperation duty on public authorities, and it's absolutely essential that you press it into service in these sorts of situations. And the other thing is, unlike Wales, and to a degree Scotland, we haven't incorporated UNCRC, and particularly Article 3, in our domestic legislation in respect to these public authority duties. But there's no reason why we can't, as a signatory to the convention, press on those making decisions the importance of child impact assessments when allocating resources.
Amanda, sorry, I apologise for having cut that short. As you can see, there's many ideas and topics, and myself, Amanda, and others here have been thinking about as options to challenge something that's a kind of an unacceptable situation our young people find themselves in. We are happy and willing to discuss to people after over coffee, tea, and later on in respect of any other ideas. And just please do get in touch to us if you have any questions arising from this. And the only thing I was going to say, I had a question put to the panel in respect to there was a case mentioned by Hannah from her Honour Judge Roberts at the CFC. Is that unreported, I assume?
It is an unreported case, but it was an interesting case because it was, I think in our experience, often when things reach that point, you often find the courts feel, as in some of those other reported cases, that they have no option but it was an interesting example of a case where the placement proposed was really so poor in terms of, and interesting, I did want to mention this actually, was that one of the factors which the judge took into consideration, and I know Kate needs to finish, was that the placement, not only but that there was a placement outside London, our child would be on his own away from his family community, but that the staff were all white staff, so we would have had 3-to-1 staff, white staff. There would have been, they were asking for permission to use restraint on this young black child, 14-year-old. And the judge felt that this was they were being asked to put this young person in a very difficult situation where he would be on his own in his home with his staff who were authorised to use restraint on him, and the implications for potential criminalising him if he was having resistance. And so I think that was just a very interesting point that came up in that.
So I apologise for everyone for overrunning that session, but I would like to thank our speakers in respect of this. And I think the next session is due to start in less than 10 minutes, but I think you probably have about 10 minutes to get yourself a coffee and anything else you need, and come back for, I think, our final session at just after 6:10, please. Thank you.
I know that you've already listened to some presentations this evening, and you're still with us now, which is fantastic. We're now going to be dealing with the third session or final session of the day, which deals with custody as a last resort. But we're going all the way through, from pre-trial detention through to the potential of an ineligible or not custodial sentence or sentence of detention for children. And so it's quite an interesting programme, actually, and we're very fortunate this evening to be joined by quite a diverse group of speakers. To my right is Mrs. Justice May. I'm sure that she will be familiar to many of you, the Judicial Lead for Children, and so significant expertise in the field. And in fact, I think we met quite some time ago when you were a judge at Wood Green Crown Court. It's not only significant expertise at that level, but all the way through from seeing the children that we represent in the Crown Court, and then in the Court of Appeal, and now in some of the most serious trials as well in the country. And then to my left, we have Sarah, who's going to deal with arrests, and also at present time is counselling the undercover policing inquiry, and albeit that's historic in nature, but to a large extent there are aspects that do impinge upon children there too. We're then joined by Angus. It's great to have you here tonight, Angus, because it's a very different perspective actually, from His Majesty's Inspectorate now and of prisons. And of course, we've had the very recent reports yesterday that deal with some of the YOIs and frankly appalling situation and treatment that some of those children experience. And then finally, of course, if I may turn to Kate, who is the powerhouse, frankly, behind our children's rights team in Chambers. And youth justice expert, obviously, former director of the Youth Justice Legal Centre, brings enormous both experience and expertise to this, and is also going to join that discussion this evening. Sadly, Mrs. Justice May, obviously very busy, lots of other important things to do as well this evening, and has to dash off. And so we thought we'd open it actually, slightly unusually, by opening it up to have a discussion and for questions, effectively. We'll have a few words, perhaps, from Mrs. Justice May first, and then open it.
Well, I became judicial lead for youth justice at the turn of the year. Maybe it was coming full circle in a way, because I started out life working life as a clinical psychologist working with adolescents, and I did a piece of original research on attribution in adolescence, essentially demonstrating that children who experience strife preferentially see strife, which puts them at a disadvantage with others who start with it. And one of the things that, I mean, other than that, I didn't know all that much about children in the criminal justice system, but what I did know was that children are children, wherever they appear, and however they seem, whether they are tall, with a beard and a low voice and looking pretty angry, they are still children. And it's important, I think, to treat them as such. And there was an opportunity, quite by chance, to discuss this in a case called ZA, a sentencing case, which where I was one of the three-person court of appeal, and it was a judgment that I gave, but of course it's the judgment of the court. And it involved I think he was 16 by the time of sentence, but 15 at the time. He had been involved with a gang who were robbing drivers of their cars. And the last in a long spree of robberies, he was involved in just one, the last of a long spree, and the driver was killed. he was, and one other 15-year-old, was acquitted of a murder manslaughter, so no responsibility for the homicide. 2 18-year-olds also on trial at the same time were convicted of manslaughter. So he had, at the time of sentence, 1 robbery. But his robbery, the trial of his robbery took place, he was charged with conspiracy, and the conspiracy involved several robberies. And he was given a sentence on the basis of a conspiracy to rob, which had ended up with the final driver being killed. And as you might imagine, the judge took it in view of that. And possibly her approach was, well, would have been tinted by the fact that the driver died, the last driver died. Anyway, the point was that she had sentenced all 4 of them to, obviously the manslaughter pair to quite a long time, and the 2 15-year-olds to a long time, and they appealed their sentence. And it was an opportunity because for reasons that I still don't really understand, none of the 4 counsel, 5 sets of counsel involved in the case referred to the youth guideline on robbery or the youth guideline on loaded weapons. And although there had been extensive reference to the overarching guideline, the sentencing guideline for children and young persons, the youth robbery guideline advocates a very specific approach, and it just hadn't been followed. And so that was the opportunity to try and push that there are these youth-specific guidelines, but also an opportunity, I thought an important one, to discuss how we treat children in the court, in the Crown Court, not just how we treat them in terms of how we address them or how the court is, but really to drill down into how we treat children in the Crown Court. Do we call them by their first names? Yes, of course we call them by their first names. Do we use age-appropriate language? Yes, of course we use age-appropriate language. And do we wear robes? In my view, no, we don't wear robes when there are children in the Crown Court. I know that the criminal practice directions say consult the children, and very often children will say, oh, I don't want to wear robes. They often say that, but I don't think we ought to, because we need to be reminded ourselves that we are dealing with children. And if you go into court just wearing a plain ordinary suit, you know you're dealing with children. It affects your approach to the whole thing, in my view. But the practice directions say that you consult the children, and you will find judges who ask the children, and you consult to. And I also think that it's an opportunity to level up the room. So if I'm sentencing a child, I will sit at the class bench and try and sit on a level with them. So anyway, ZA was an opportunity to address the manner in which we conduct hearings with children, particularly hearings in the Crown Court. This is all everyday stuff in the youth court. Youth court, DJMCs know this, we do this all the time. But the youth court is a very particular place, and in particular, there is no press in the youth court. There happens behind closed doors, there are reporting restrictions. And in fact, only the child's parents are allowed to be the evidence comes into view. It's just them and the youth justice team on the side. So ZA was an opportunity to address how we treat children in the Crown Court and to ram home the message that there are particular, for some offences, there are particular youth-specific sentencing guidelines. And people to be aware of them. The other pet project, in a way, was to try and prevent the prosecution or defence, as they sometimes do, just going straight to that bit in the youth sentencing guideline which says a half to 2/3. There's actually a whole stack of stuff in the guideline to go through, which is very relevant to sentencing a child, before you ever get to the half of the 2/3 paragraph, which is more than 2/3 of the way through the guideline. So it was also to encourage courts, judges to, counsel on judges to look at all the stuff that's in that incredibly useful guideline before getting to sentence. So, I suppose my message would be take a practical approach. If you are representing a child in the Crown Court, if the judge has not, or the court has not contacted you in advance about things like roving, use of first names, where the child is going to sit, is the child going to be in the dock or preferably out of the dock? Has there been some sort of risk assessment between the judge and security about where the child is to sit, and who they are to sit with? If you have not been contacted by the court, if the judge has not been proactive, then you ought to be contacting the court well in advance. To do it the day before is not good enough. If you know you're representing a child in the Crown Court, contact the court well in advance, and if they don't seem all that receptive, just call out Part 6 of the Criminal Practice Directions. It's all there. It's all there in the Criminal Practice Directions. Read Part 6. Think about what your child you're representing will need and contact the court in advance to eventuate. Insist. And insist through the Criminal Practice Directions, because no judge is going to disagree the Criminal Practice Directions, which will be written a very busy list. They want to filter it.
No, absolutely. I've got to say, in fairness, there is a real deficit across the bar and indeed the legal profession generally in terms of knowledge when it comes to sentencing of young children or children with stop. And it is a particularly complex area of law. I don't think it's simply the judiciary that falls into error in that respect at all. I think, unfortunately, there is a tendency to use the shorthand of going straight when it comes to sentence to the overarching guideline, to that very helpful line that looks so attractive, which basically just says either half or 2/3, dependent upon age and maturity. Go to the adult guideline, think, okay, well, that's what we do. If the adult guideline says 6, well, he's 17, maybe we end up at about 4, that sort of combination. And that's entirely the wrong approach. And ZA is incredibly clear in setting out what the correct approach ought to be, and hopefully will start to remedy some of that deficit by getting the message out there, both to practitioners and indeed more broadly, because the numbers of children that come to the Crown Court are actually very, very small indeed. So the vast majority of judges, I would have thought, would never actually encounter a child in reality, or very rarely, a couple of times a year. And so, and inevitably for the more serious offences, because
they wouldn't be in Crown Court if it wasn't more serious, although they can be there if they're charged with an adult.
In the vast
majority of cases, they'll be there because it's very serious.
And that in itself throws up a whole complexity in relation to the different types of sentences that are available, lengths of sentences, how you calculate those sentences, how you go about imposing the correct sentence, because the underlying rationale and principles that drive those sentences is very indeed. And so we are all very grateful to ZA because it really is, it provides a blueprint, frankly. And as Justice May has already pointed out, we've got the law already in place. The law is all there, both in relation to a child's participation at trial, but also in relation to sentence. But what we don't have yet is it fully entrenched in practice. And just opening it up then really to the floor, are there any particular difficulties that people have experienced when it comes to either engaging different adjustments in relation to the trial process, or indeed sentence that they'd like to canvass or ask questions about?
I have a question. I'm not a criminal practitioner, so forgive my ignorance, but I'm just thinking about the immigration law context and the creation of many more immigration offences and criminal offences, and thinking in particular for age-disputed children, just what reflections do you have on what
what can be done by the judiciary or any practitioners, given the very strange position that we're in, where an immigration officer may well decide that a person of X age, which is considered willful, and they go through the criminal process, going back to them to inquire if there are questions about their age. And so it's a difficult question for criminal adults. But if you can shed any light on that, the reflections that we have.
Well, I've never done an American violent assessment. They come to me with those assessments always having been done. In the same way as the civil courts have started to catch up on how you treat vulnerable witnesses, I would hope that the courts will catch up on how you treat children in the court. And maybe if the Crown Court may be the place where that starts to happen in the same way as it's been the place where how you question vulnerable witnesses has started to happen. I think I can't contribute any more than that.
Can I just add into that as well? Because I do civil law, and where I'm representing a child or vulnerable adult, and I always think to the advocate's gateway as well, which, you know, in plenty of time I'll flag it up to but I'll also flag up to PTR as well, and make sure the judge is in the same section of that. Massively useful, but not everybody knows about that, and we should do, really, because we found some cases haven't heard of that, but really to say this is the thing that sets out all those institutes that people can use more and more in civil courts. I suppose just for those of you that aren't familiar, within the criminal courts, counsel it's not mandatory, but it almost is effectively, have undertaken what's called an advocacy in vulnerable courts in relation to how to deal with vulnerable witnesses, how to ask them questions, all of those sorts of things, how you cross-examine, elicit best evidence, in short. Specifically, initially in relation to sexual offences in children, but it's become a much broader thing now. It was also subsequently rolled out to the family courts. And so family practitioners are also, I think, familiar with it. But certainly my understanding is that it's not more broadly rolled out in terms of civil practitioners. But the material is frankly transferable to any jurisdiction. It really deals with breaking down how to ask vulnerable individuals, whether they're children or adults with cognitive difficulties, questions properly, and how to achieve their best evidence. I'd certainly advise everybody to go away and look at it, because I suspect that the cohort of individuals that you typically represent fall significantly within those categories. And it's an incredibly useful resource. And indeed, you're also involved in that at one stage. I believe you are in a temple, yes. Unfortunately so. But it's a really useful resource, and so go and have a look at it. In short, it's very, very practitioner friendly. It does give examples. It breaks things down. It makes you question how you formulate your own questions, which is actually a really I think useful, also soul destroying on occasion aspect. But what you do realise is how much longer it actually takes you to formulate those questions. It really cannot be done on the hoof. It's very difficult to formulate the right type of question in certain circumstances. But I'm afraid, Irena, again, I think from my perspective as a criminal practitioner in the criminal courts, I've never yet come across a situation where we've actually had to have some form of formal age assessment. As I said, most of the time we have individuals who already had that assessment completed. I think the only time I've ever had a case like that was when I had a client who said that he was 16 at the time and then later told me he was 20 prior to trial. So luckily that issue was completely sidestepped, bless him. But he was actually, ironically, the victim of modern slavery and trafficking for cannabis farms. So one could see where that would come from. But we don't generally have those types of hearings. I think we'd encounter all sorts of difficulties if we did. And in principle, certainly we're supposed to, if that issue arises. And there is some case law around that, but not very much, just because it's such a rare thing.
And actually, you've reminded me that the other thing we're having issues that I wanted to address in ZA and that I try very hard to do when I'm in the Crown Court is to use age-appropriate language for the children. I'm not sure that as lawyers we always do that. And I don't think dealing with children is complex so much as really, really time-consuming if you were to do it.
Yeah, I was just going to add that the issue around age disputed young people is likely to be more relevant to the increasing prosecutions of the right. The issue is exactly the point you're raising. This is criminal practitioners. We're just not alert to it, and it's something that really does probably need some awareness raising.
Will take place in the magistrate's court because the pressure, that's where it rises, and the pressure is that the majority of people including disputed children plead guilty. They do go to the Crown Court for sentence because the dispute is serious, and by that stage they've already been in prison, adult prison for a very long period of time, and the impetus to just have a sentence and be released is overwhelming. So one question I was going to ask is, does seem there's plenty of guidelines, there's plenty of case law, but there is systemic inability for it to be entrenched within the system. And it's about, we had a session this morning about academics who are looking at what's happening in police, possibly. There hasn't been very much research done. What are the safeguards? How do they actually work in reality? Seems like we need a chief inspector of courts because we have got lots of brilliant guidelines and these are brilliant and welcomed, but how does it actually get entrenched so that it doesn't require somebody to raise it? It's part and parcel of the process. And certainly the experience of representing individuals who are disputed children who are being prosecuted wrongly as adults, the system is failing to ensure that that issue is addressed across the board, whether it's the defence counsel, prosecution, CPS, and the court. So how does that happen? And it's happened in other contexts. So I think it is looking about how you monitor what happens in practice in order to make sure that all the good intentions become the reality.
I suppose part of the difficulty there is it's effectively what happens in the police station and then what happens in the magistrate's court, because we say that's the first contact and that's where individuals be. And I don't know what the answer to that is. Save as to say, we've had a similar situation as I'm sure most people in this room will be aware in relation to the prosecution of individuals when they have live defences in relation to trafficking and modern slavery. And that sequence, that line of authorities has taken quite some time actually, and it's gone backwards and forwards, and we've had numerous judgments from the Court of Appeal in relation to it, and awareness has built, and I think that's fair to say that certainly those advising are much more aware of those obligations and also the availability of a defence now to explore it. But again, I think the real difficulty is when these cases arise, I suspect most of us never actually find out because they get sentenced, they go and then they go off and then they become your client. But I don't really know an alternate way of embedding systemic change aside from education. And part of that comes, sadly, from the Court of Appeal when it goes wrong. But it's getting those cases back into the appeal to be dealt with, so that we can have very helpful judgments like ZA and other ones that come down.
If I may just raise a question, just to say on ZA is it talks about a root and branch difference of approach, and when we're talking about that, it is a culture change that is needed for awareness amongst both barristers and solicitors representing children, and I would take away that we need to make sure that criminal practitioners are aware to ask appropriate questions to ensure that the person they're representing's identity and date of birth is accurate where they have arrived in circumstances where their age may be disputed and
have identity documents. So thank you for that alerting us to that issue.
Just on the general point of embedding change, in the family division, there are quite a few authoritative judgments now placing the obligations for ensuring that no party faces barriers to effective participation on all parties and the court. And so that's definitely affected some changes. There have been a few appeals that have led to reviewings of non-drawing up finding backing simply because it will be undertaken at that time.
One slight worry is that appeals only come, appeals on sentence or on trial, will only come to the conviction, will only come to the court of appeal where something has really gone wrong. And how you treat the child will not always be something that has gone wrong. I mean, it will have gone wrong, but it won't be the sort of gone wrong that will justify the case coming to the court of appeal. So I have a bit of a worry that there will be ways in which children are treated in the courts that would not generate an appeal, but is nevertheless something that we would want to take away. All judges that I speak to about children in their court recognise that it involves a difference of approach. But sometimes their lists are just so full that they come in and they're on an escalator which is, they can't step off in terms of their mindset. So when I talked yesterday about a root and branch difference of approach, it involves stepping away, getting into an entirely different mindset. And sometimes the lists just aren't, the way in which the case has been listed just doesn't allow that to happen. And a way of ensuring that it does is to make very clear, that requires to be clear to the court when listing that this case involves children and the judge will need time to read in and time to sentence and time to think about their sentence, because not only thinking about what sentence to give, they're having to think about how to explain it to the child in age-appropriate language, and all of that takes time. So my own view is that sentencing a child needs a day. You need a day to sentence a child. So, if you or your clerks are listing a sentence, ask for a day.
Question at the back. I can't see you.
I was online, but I was so inspired with what was going on at heart. See down here, you can see the diversity of the I never had to see diversity of the because we talk about age because we're dialogue. But what about the cultural influences that go with that as well?
I agree. It's a real problem, and that is why as judges, I think we have to pay really close attention to educate ourselves, and pay really close attention to what's going on in the reports. That's really part of the story, and I absolutely agree with you that there is a diversity issue. In the moment, other than educating yourself, it's very difficult to know how to, what else to do. So I'm absolutely open to suggestions about how to do that.
So everybody has diversity of policies.
Yeah.
Is there not a tick box for, how the records are actually, the child was listened to throughout the whole process. We know about habits of research. We know about high rates of action. So take this consideration, and actually you can pick up the folder and say, yes, all of these listings have been taken into consideration.
There are not those sorts of tick boxes when a child comes to the Crown Court. A lot of what you're talking about, the stuff in searching, that'll be at the police station on matters of diversion. I mean, the police are diverting many more children now than used to be. Looking at figures figures the other day. There were 1,200 children in Crown Court in 2010, and there are 400 now.
There are very specific, there's very specific guidance actually within the new sentencing guidelines, and indeed within the Equal Treatment Bench Book and the use of the Crown Court Bench Book in relation to racial disparity. The gross disproportionality actually is what it is in terms of young black boys effectively are grossly overrepresented or more than familiar. And it does deal with aspects of that. The tricky part, I think, from a practitioner perspective, is how you make those representations that they are in some way taken into account and factored in. They're very difficult submissions ultimately to make. And because how do they get factored into, if you just take a sentencing guideline, whereabouts does that come in the general stepped approach in short? How do you invite a judge to take that into account? And there's some guidance, but it's still quite nebulous actually within the guidelines as to what impact it has and what role it plays. Obviously, aspects of it may, because of adverse child experiences and a lot of deprivation that often accompanies the cohort that we certainly I represent, comes through. But how do you specifically address those sorts of issues, and where does that fall when it comes to actually passing a potential sentence? I do think at the present time we're still struggling with that actually. I don't know what it's like from a judicial perspective.
You know it exists. Of course you do. So you try and educate yourself.
I think the only thing to say is don't be afraid. The resources, again, it's a little bit like children generally. The law is there, the guidance is there. Don't be afraid to go back to it, anchor your submissions to it. It's there, it's in black and white within the guidelines, whichever guideline it may be, whether it's for trial modifications, whether it's for, as you say, looking at different cultural aspects or looking at how it implies in sentence. And I think certainly we as advocates have to be that little bit braver, and it's certainly something that we've been discussing with pupils and different sorts of training courses. It's not I don't suggest for a moment it's an easy thing to work in, but it's all there. We have to confront ourselves with that too.
I don't know, but it's a really poignant question. You can't know what you don't know, and if you don't have shared cultural experiences, you may miss a nuance about the case. And I guess that's where preparation on the part of the legal team to really make sure that the judge is made aware of anything that might be relevant or during trial, so that any cultural insensitivities, lack of awareness that may prevent that child from going to their trial is detention. It is a challenge. And certainly in Garden Court Chambers, we seek to try and promote diversity and encourage diverse backgrounds to come into the legal profession, because that is how we are going to change things when, as you say, people sitting up here are more reflective of wider society and the people who are having decisions.
And I'm very aware of some research that it is attached to the sentencing in the appendix to the Crown Court Compendium, about how important it is for children who are being sentenced to understand, to feel like that the court have been understood. They've been understood, that their situation has been understood, that they have done a bad thing, but they're not a bad person, and that there is a future for them. There is something to look forward to, things that they are good at, and that has been appreciated, and that can really make a difference to them. So speaking as a judge who is sentencing them, understanding cultural differences, understanding how they may impact on the child's view of themselves, or what they want to do when the sentence is finished, all of that is absolutely key, because I want to convey that to the child so that if there is hope of redemption, they get that. I don't want to leave them with no hope at all. Sentence is unavoidable if they committed a crime, but like I say, they've done a bad thing, but they're not a bad person.
I think that's a distinction that's often unfortunately lost. They lost the work that we do.
And that is so important. We have recently been far away relative. Those children who are in custody having received sentences, if they feel that the decision that's been made about them is fair, they're much more likely to engage with any interventions that are available to them. They get stuck. They feel that there has been injustice around their conviction of their sentence. So, yeah, thank you for raising that. It was a nice opportunity to bring in the contribution that we have now. The perspective of Angus's perspective of seeing what happened to children once they reach the city.
It's not at all that I'm not interested
Oh.
in this, because I've got no.
I wouldn't be that offended. I'm going to stand up mainly so I can see my own presentation. So,
Yeah. Shall I get out?
Yeah.
Get in? Yeah.
See what happens here. Oh, there we are. This is by magic. Right. So I'm Angus. I lead the inspections of young offenders, institutions, and I take part in inspections of secure training centres. It's a bit of an oddity in England and Wales. We decide to use 3 different types of detention to hold about 500 kids or half a secondary school. No one can explain to me or you why we do that, but we do. We don't have anything to do with secure children's homes. They're inspected by Ofsted. And the findings in this presentation are mainly about the bulk of the estate. So about 80% of kids are in YOI, so about 10% are split between the 2 other sectors, which again makes a mockery of having 3 different sectors. So let's start with the good news. So diversion has worked. There is no doubt about it. You know, when I started working in prisons in 2006, there were just north of 3,000 kids in custody. We have about 400 of them in custody today, plus another 150, 170 young adults who are being held back because the prison service can't manage its own population. And so this is the one really hopeful thing about youth justice, is that we have fewer people in custody, and those kids who are doing stupid but at the lower end of the criminal justice spectrum are now in the community, either doing a community order or with very little intervention, which supports the mountain of evidence that says that most children will just grow out of it. So we've also got, along that same time, some real differences in why or what the reasons are for these children being in custody. And put bluntly, the child-specific sentences are now the minority of the reason that kids are in custody. So the DTO is dying, and we see a huge increase of children who are on remand, who now make nearly half the population in custody. And we also see a more moderate increase in longer sentences for children. And that's really important because the large majority of those kids that are in custody on remand will be let out when they get to court, and about a third of them will be acquitted completely. So it's a bit of a waste of money, and it's certainly a waste of opportunity with those children. And these sites are struggling anyway, so to chuck in another 45% of the population just makes them topple over. So that's not brilliant. We also have been much more successful at diverting white children than we have black children. We have diverted black children from prison, but the reduction has been slower, and so they're making up more and more of the population. So now, if you're black or Asian or of mixed heritage, you are going to be making up more than half of the children that we see in custody. And that's changed dramatically in my career, from something that was much more reflective of the population at large. So we get on to what we're finding in custody. So you don't really need to see the detail of these charts, but what we see here is 2020, just before the pandemic, was a real low point in children's custody. We see more restraint, more self-harm, more assaults. Ignore this bit, this is just for 20% of the population, so it's sort of irrelevant on a population basis. So we have the worst year ever And even though some of these graphs don't go back, they change the counting rules, but whichever rules you use, if you double it, if you triple it, it's still going to be higher here. And then we have the pandemic, where the policy is to lock everyone in a box, so it's very, very difficult to assault someone, and very, very difficult for you to be noticed if you're self-harming, and very, very difficult to restrain someone from the other side of a locked door. So we see a little reduction here. They still do a bit of it, but we see a bit of a reduction. And now we see the last reportable year, we see a trend back towards the historical highs we saw in 2020, which, as I say, were the worst years on record in terms of a rate. The government likes to publish a number because it tracks the reduction in the population and masks the rate increasing. We have just a sort of bit of context. I can't publish the names or the things on here because it's management information rather than government data. But it just gives you an idea on assaults per 1,000, the difference between a children's prison and an adult prison. So we have every prison in the country on the bottom here, and we have a rate of assaults per 1,000 here. And this is a child's place, 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 and this is a child's place. So they are not just small adults, they are completely different in how they behave in custody. It's, you know, and you can see the impact of age because this is a young adult's place, this is a young adult's place. I couldn't give you the ones from memory, to be honest. But so you're talking about a 4, and this is the average here. So you're talking about a place which is much more volatile and much more difficult to manage. So, as I say, they're not just little adults, they are completely different in how they behave and the interventions they need. And what the evidence from inspection shows us is that at the root of the problem is something that I would like to call a sort of conflict, keep apart and time out of cell sort of vicious cycle. So what you have in custody is a lot of people who have problems with conflict, right? Some of those problems are very real and to do with the groups that they associate within the community. And that's very difficult for the prison service to manage. However, the prison service manages to create other conflict between groups by locating people in different wings where they shout abuse at each other and what they'd like to do to each other's mothers. And then when they come out of custody, when they come out of their cells, they are ready to assault each other. And the sort of group mentality that is created in these institutions means that if I'm on A1 at Cookham and we don't like B2 for no other reason than it's got a different letter and number, then I will be expected to assault every single person I see from that unit. And if I don't, I'll be assaulted by my counterparts on A1. And so there's a real pressure in terms of conflict. And the response to conflict and behaviour management is woefully inadequate. It's better in some places, it's awful in others, but generally it doesn't work. So what you would like to see in a place that deals with behaviour management is some sort of acknowledgement of when you do well, some sort of praise at the lower end and something better for those that engage or are going to education or are succeeding in some other part of their existence. And you'd expect some consequence for someone who came out of his cell fighting, right? And I think that would be perfectly appropriate. The problem is that what these sites are delivering is just below the statutory minimum, right? So every day at Cookham Wood, you are delivering the least that you are legally allowed to do and slightly below that, right? Every day at Warrington, that's what you're delivering. The average kid is getting out 2, 3, 4 hours a day. They might get to school, but more likely they'll spend more time getting to school and being transported back than they will in education. So that means you can't deliver. You're right on the edge. You can't deliver anything more for those that comply. But also, crucially, you can't take anything off them because you're not delivering anything in the first place. Right? The real woe is this thing that they like. And it sounds sensible. Having a fight with someone. But how these sites absolutely out of the... So say the cell with you 5 hours, and then now on an hour and right context. I've been to 2 Wood. Think of the 80 kids. They had about 600 at Warrington. Shy of 90 kids. They had just shy of 400 keeper parts they were managing. And what that means is that you can get nothing, right? You don't get anything in those, right? Because actually you can't go and learn English if that's what you're meant to be learning, because the person in that class you have a conflict with. You can't go and work on your offending behaviour programme because the person who sat in there has a conflict with you. So if you do make it to education, it's very, very likely you'll just be shoved in any old class to do whatever it is that they're doing. So you have this sort of vicious cycle where you have conflict, the responses keep apart, you lower the time out to cell, you've got more time to say nasty things outside your window to the people you've got conflict with, and the whole thing just cycles round again. And in that context, it is very unsurprising that most children in custody don't feel cared for. So we published a report yesterday where we survey every kid in custody every year, and about 80% of them respond. And of them, 46% of them felt cared for in this system. So, and that's significantly worse than the year before. So you have this very depressing situation that we find. And to try and work out why, I've sort of got some musings. So you both have too many and too few staff. Youth custody is not a place short of resources, right? At Cookham-Wood, 90 kids, 80 kids, whatever I said, 80 kids at Cookham-Wood when we were last there. They had over 350 staff. And the same for Warrington. You have top-heavy management structures, which you wouldn't see in any other sector. You've got sort of 20 people on the senior management teams. Again, 80 kids. These people, they can't get a weekly conversation with every kid that they're looking after in lots of YOIs. But in my view, if you've got 20 managers, you could run that just through your SMT. You know, you wouldn't need the other staff. You know, they could just take 3 each, you know, and do it on a Monday morning and then have their meeting about strategic management, right? So you've got top-heavy management structures, and you've then got lots of other staff who don't carry cell keys. And that's really crucial, because if you can't carry a cell key and the kid is in the cell, you're not going near them. It doesn't matter if you're a psychologist, it doesn't matter if you're a teacher, it doesn't matter if you're a doctor, right? And because you have high levels of vacancies and turnover in what are called operational staff, prison officers, right? You can't get access to the children. So we have a real problem of lots of resource just pointed in the wrong place. And all of these other professionals, which are quite expensive, twiddling their thumbs. We have huge NFA rates, wasted appointments in healthcare, in YOIs. And the reason they get round it is they just over-resource it, you know? So there's a real problem in terms of structure, too many and too few. And then there's been a bit of strategic drift. So since that time in 2001, the population has gone down dramatically, but actually the proportions that are in different parts of the prison estate are the same. We still, in 2001, 80% in YOIs, with 3,000 kids. In 2023, 80% in YOIs, but we've got 500. Like, no one's taken a decision to say, actually, what works? Why have we got this estate? Why don't we take the opportunity of reducing numbers to do something different? We see a regular churn of senior leaders from both individual establishments. So we published Warrington inspection report yesterday. They've had 4 governors in 3 years before we got there, with predictable results. As I said at the start, no one really knows why we've got three different types of prisons for kids, and there's soon to be a 4th. So we're going to have 4 different types of prisons for 400 children plus 170 young adults. Like, if you explain that to the person sat next to you on the tube home, they'd think you were crackers, and they'd be right. It's not, you know, that's just because no one has made a decision, right? We've just got the estate that we've been given. Every time there's a problem in these places, there's a new team, a new manager, a new layer of process, and none of them operate effectively. So what you have is this illusion of safeguards, where everyone is sort of taking a cursory glance to see if this kid's all right. And 20 people have had a look, so it must be all right. But none of them have looked properly. And so nothing gets better. This is one for me. We've got 4 different inspection regimes to go with our 4 different, because the inspectorates are struggling to link up with the legislation, ourselves, Ofsted, the CQC, and actually you can throw in Estin and the Health Inspectorate in Wales. A secure school that's taken 7 years to build, despite the fact they own the building, and they didn't need any new legislation. It just beggars belief. And there's no prospect of another one. So I wish it success, because any bit of light in this space would be good, right? But at this rate of improvement, my child will be retired by the time they replace the estate, let alone me. And all of this is costing a fortune. So in the last accounts that the Prison Service published, they spent £190 million on the YCS. They only look after 450 kids in that year. It's gone up slightly, as I said, because of the young adults. So I don't know how they get so little outcome from the £422,000 per kid that they're spending. It makes no sense to me. So I think there are some real issues about how children's rights are protected within the secure estate, the secure estate's capacity for improvement, and also a sort of real hard look at the model of custody, and maybe a bit more investment in frontline prison officers and a few more of these episodic professionals that don't have a relationship with children. And some of these are the people that we like, psychologists, social workers, teachers, but they're not doing anything right now. And so it's not as, we can think about their role and how it impacts on children's lives. So I'll stop there, but I'd like you to remember the first slide, because while it is a pretty awful state right now in children's custody, there are many, many fewer children experiencing that today than they were when I started my career 16 years ago. So, thanks.
Thank you, Angus. I think what we'll do is, if we move now to Sarah and then take questions at the end, and then that way we can have a panel discussion, probably a little bit more interesting. Thank you, Sarah.
I can work this. Yeah. I've been asked to come and speak today about a case that I was involved with a few years back, and it was just a couple of years back, and it was about a young lad, 14 years old, who was arrested at 5:30 in the morning by a couple of police officers braying on the door. He was in bed, he was dragged out of his bed, he was hauled down to the police station. He was crying, his mum and dad were crying. Dad asked, "Can I come with you?" "No, you can't." But eventually they said, "Okay, we'll jump in the back of the police car and you can come in with him." And he was held for about 6 hours. And he'd been picked up 12 days after a mobile phone had been stolen from a girl outside their school. And it was snatched by his friend, returned to her within minutes, but the SIM card and the pink Diamante phone cover was still missing. So fairly low level, if valueless items were still missing. And for some reason, the police thought that it was justified to go round at that time in the morning and haul him down to the police station. There was no consideration given as to whether that was necessary, whether there was another less intrusive way of dealing with Sanjay. He was a boy of good character and had been in trouble with the police before. And
what happened with that case is that firstly they complained to the IPCC, I think it was still at the time, back in 2011, and nothing really much came of that, other than they found that the police officers had been a bit abrupt with their language at the time, a bit rude. And so he brought a civil claim for false imprisonment and assault. And that trial was what I was instructed in, and that was in 2021, and that was up in Mansfield. Now, this is a young Asian boy who was 21 by the time that we got to trial. It was an all-white jury, and I think the woman's point at the back about diversification is important when you're looking at jury trials as well. And what the judge found on the basis of the jury's findings, and they found against him on every point, they thought that it was reasonable that he had been arrested and detained at the police station. They found that even though the custody sergeant had ticked boxes to say that there was outstanding material, that there was a co-accused still on the loose, there wasn't, but he ticked those boxes to justify the detention at the police station. So even though the jury had found that he lied, the custody sergeant lied, got it completely wrong, it was still found that the arrest and the detention was lawful. And the judge, when he made his remarks at the end, when he dismissed the claim for false imprisonment and assault, he said, and I think I'm going to skip through the slides because I know I don't have very long in relation to this. What he said in the county court, the second paragraph, was that the decision made to arrest Sanjay at 5:30 a.m. by rousing him from his bed is disturbing. The timing of the arrest was tied to the shift patterns of CID officers, which is extraordinary. Although the arrest and subsequent detention was reprehensible, and the way in which police powers were exercised in relation to Sanjay lamentable, it was nonetheless lawful. Couldn't believe it, could not believe it. We took it up to the High Court, and Justice Cotter was brilliant. He heard what we had to say, what the basis of our appeal was, and he looked at counsel for the police, and he said, "This is a child." And she said, "Yes, but he'd committed a very serious offence, a robbery." But he was a child, and he literally put his head in his hands and slammed them down on the desk. He was a child, and from that point on, I thought, great, we've won this. And he gave a fantastic judgment where he listened to every one of our arguments about best interest of the child, about all those international and domestic laws, which mean that the police are not law unto themselves and just have to comply with the Police and Criminal Evidence Act when they're going out and arresting people. They have to comply with all this other stuff as well. Section 11 of the Children's Act 2004 requires that the police, the chief officer, needs to have regard to safeguard and promote the welfare of children. Article 3 of the UNCRC provides that the best interest of the child should be the primary consideration. And Article 37 of the UNCRC says that arrest, detention must be the last resort. The police had paid no heed to that whatsoever in this case. And in fact, when PC Lapland, the arresting officer, when I asked her about that, about her training, what about the best interests of the child? What about less intrusive ways of investigating this offence? I said, did you know about that? Had you been trained about that? Well, yes, we have some training on the best interest of the child. I said, so how did it apply in this case? She said, well, he wasn't a child, he's a teenager. Could not believe what we were hearing, and the jury didn't pick up on that at all. But Justice Cotter did, and in his judgment in the High Court, he basically emphasised two key points, I think, and And that's firstly the best interest of the child. It's significant. It has to bear on any arrest of children. And at paragraph 99 of his judgment, it's set out here exactly what he said in relation to that. What was of interest is the Police and Criminal Evidence Act dictates what police have to do in terms of an arrest. The codes of practice in relation to that, Code G, says what needs to be taken into consideration when you're looking at arresting anybody. You know, what do you have to think about to ensure that the arrest is necessary? Things you have to look at, the circumstances of the victim, the circumstances of the suspect, the needs of the investigative process, and those sorts of things. And in this case, they just weren't considered at all. The police had turned up on the back of what they termed an arrestogram. They had been told, you're on shift, go and arrest this person. They knew what they were arresting for, a robbery. They knew where and when it had happened, 12 days before. They didn't know anything about the victim, the circumstances of the suspect, and they didn't know anything about where they'd got to in terms of the investigation. So they hadn't turned their mind to it at all. And one of the problems is, in Code G, children aren't mentioned. There's no mention of how you deal with children. In Code C, when you're talking about detention at the police station afterwards, there's some reference to children, but not very much at all. But the extent of it is that children shouldn't be arrested at school if it can be avoided, and you shouldn't arrest and detain them too late at night, particularly on a school night. But that's about it. There's not anything other than that, really. And in general, timing was never anything that could make an otherwise lawful arrest unlawful. It was found in the case of Moocher against the Chief Constable of South Wales. When people were arrested about 6:30 in the morning, people had tried to say, well, you know, that's unreasonable, it wasn't necessary at that time. And the judges in that case just said, no, timing cannot affect an otherwise lawful arrest. But Cotter in this case said, absolutely it can. Why was it necessary at 5:30 in the morning for this young lad to be hauled down to the police station? What if it had been 2 o'clock in the morning because it suited the officers who were on night duty? You cannot say that timing makes an arrest necessary or not necessary, that it's not a factor. Absolutely is. And so this sets the precedent for that, especially when it involves children. And so that, I think, is the key thing about this case. What it provides is higher judicial comment on something that doesn't really have much comment already, and it doesn't have much guidance at all. Miranda Bevan and Vicky Kemp, who were talking earlier this afternoon, have worked along with another couple of academics, and I fed into them a little bit to try and get a change in the codes of practice and to try and take it through the parliamentary groups and the College of Policing to try and make a change that's flagged up. Police officers have so much that they're thinking about. They need it in black and white in front of them. They need to be reminded all the time, this is what you do on an arrest. They can say the caution, you know, that isn't printed, that's their bread and butter, they're doing that every day. But they need this stuff as well in relation to children. This is a child, have you thought about this, have you thought about that? Really something simple. It should be in the codes of practice, and that's something that I think they're still working towards, and this case at least is helping them to be able to argue that. I've jumped about on the slides a little bit. Again, to follow on from what we were saying as well about children who shouldn't really be in detention. That diversion is so important because, as we know, those who are brought into the criminal justice system tend to end up staying in the criminal justice system, and they'll be recidivists. One thing I think in terms of diversity as well, and I was going to ask a question about why is it that white children are being diverted away from formal detention as opposed to black children, and whether that was
something to do with adultification of black children, and we know that seems to happen. One thing you can definitely point to is resources. And so if you have two comparable children, you have a white middle-class boy who's accused of, I don't know, even sexual offences actually in a school context or in a what may or may not be a consensual sort of relationship, boyfriend-girlfriend relationship, and then you have a black boy from a very different background accused of the same things, what you will find is that that white boy's parents and family have the financial resources to go get representation early, make proper submissions and representations, firstly to the police, secondly then to the CPS if it goes to the CPS, get that child into some healthy relationships courses or something of that nature, show that they are receiving different types of help and treatment and all those types of things, make those representations and often end up, unfortunately, with a very different charging outcome. I certainly see that. I represent these children and they are very different outcomes. But by the time that I'm typically instructed, for example, we are generally instructed in relation to a child from a very much, on what we certainly the cohort of children that I represent tend to be from deprived backgrounds predominantly. By the time I see them, we're already so far down that path. They don't have the resources to do all of that work in any event, or get some psychologists to work with them and really, undertake that level of engagement and intervention. And so you are, unfortunately, already on that path to criminalisation. That's one way in which we see diversion going in very different directions from a very early point. And that, frankly, is an incredibly depressing picture if you're representing these children, because you do see two very, very different outcomes. There's been it's a very difficult issue, though, to disentangle generally, I think. And what you do tend to also see is disproportionality more in cities like London, for obvious reasons. And that then impacts upon the policing choices. Certainly from just as a pure anecdotal perspective, I come from Gloucestershire, from a tiny village, and the policing and the diversion that they will undertake there is very different to what you might see here. So you do have those geographic differences which also feed into that disparity as well. I don't know whether anybody else in the room has any other insight into that particular aspect. It's an incredibly depressing aspect of the work that we do.
I think in terms of getting to prison, I think what most children who come into prison are either coming in for an incredibly serious offence. Right? So we have, I don't know, the last time I read 1 in 10, 1 in 7. I think it's were in for a homicide or accused of a homicide. Very similar at Feltham, and slightly lower proportions in the north of England. Or you are dragged into the system earlier on, and you end up escalating through the tariffs until you get prison. They're the sort of the two options. I've got to say, I never meet a middle class kid. Right? I go around these prisons every year, every prison, never meet a middle class kid. So about 6 out of 10 of them are looked after before they're in custody, which is a hilarious euphemism. And so I think there's absolutely some truth in this sort of this idea that if they had more resources, they would get a different outcome. But I do think there is something around that when we looked at what we had before, we took the easiest stuff first. So as a society, we decided that if you stole cars, you wouldn't be going to prison. Yeah. In 2006, lots of people were in for twocking, right? And
you never see a twat.
You never see a twat. And
that's taking without consent for these.
Joyriding, actually, for most children, is what it really comes down to.
So as you drag, and I think it's more about this early offences that are relatively minor, the criminal justice system being criminogenic, and that escalating through the tariff sheet, and that's what the system is struggling with, to divert those people away.
Even just, sorry, Angus, do you attribute the increase of children going into custody on remand at all to the failures by local authorities to provide Section 20 accommodation?
Okay, so there's one thing, so I can answer this, but the organisation doesn't, right? So we don't comment on the reasons why people are there. We take it as read. The nearest we go to it is in immigration detention. It's just, it means that we comment on conditions and treatment rather than the reasons why they're there. I think there are several issues. There are issues around absolutely accommodation problems in the community, and we see that proportionally more with girls. There are very few girls in custody. I checked the other day, there were 7 in September, but proportionately more with girls. And yeah, you do get people being dragged into on remand because of a lack of other option in court. And if you have sort of everything boxed off and neatly tied up with a bow, you're likely to get another you're likely to get bail. But yeah, we did a thematic inspection on remand with the probation inspectorate recently.
Yeah.
Thank you. Shamefully, I didn't know the date. I'm sure it was coming out this week. So.
It's slightly off the topic, but I wanted to ask you this because obviously the one other side of the experience of youth custody is the evidence of abuse that is inflicted on children by staff, and we know that is a long-standing recurring issue, but we've tended to only really know the magnitude of it if Panorama or some other undercover reporting has gone into there, and obviously that was exposed by in the Medway institution, and I work in the immigration context. Similarly, house immigration and the centre was only really exposed just how serious the abusive situation was through undercover reporting. And the Rought-Brooks inquiry has now reported in September and has obviously the inspectorate and other bodies that have oversight for that institution did not identify the true nature and extent of very serious abuse that was taking place in there. And I know that obviously the inspectorate has had to think about that, and I just wondered in the context of youth institutions, which all of them, I mean, there isn't one of them that hasn't had some expose, or even has had expose, has been identified as having serious issues with not just problems that we talk about segregation, which is huge, but also abuse by staff. And I don't know what kind of reflection that the inspectorate has on why that occurs, why it's not so easily identifiable, and how you might do things differently in light of that.
So the first thing is it does get identified, but we don't film it, right? So when we write a report, I published a report last week about Bedford Prison. It's an adult place, but I published a report last week, wrote a letter to the minister, put it in the public domain, and it said we found instances of illegitimate force being used. And that's what that means, right? So when you read that in our report, when we say it's illegitimate, we mean the staff member was not meant to be using that technique or taking part in that restraint at that time. Now, the fact that doesn't, I mean, I don't know what more we can do. So we don't see it all the time. And that's generally because in the same way that the criminal justice system fails as well, is you can't be everywhere all of the time. And generally people who are doing things that they shouldn't be don't advertise them to you as you come in. So when I walk on the way, they're not hitting children with sticks or so I think that there's an acknowledgement that inspection will only ever find out some of what's going on. But there are also cases where the system works. So I remember Wetherby a few years ago, it was taken essentially for a punishment beating in one of the CNR, one of the emergency stairwells. And it ended up being reported by a very courageous prison officer because the one thing that can happen if you step out of line in these institutions is similarly to what I said if you're a kid and you step out of line, you expose yourself to threats of violence, threats of reprisals on both sides, there was a proper prosecution and those people are now in prison. But as I say, without a television camera, you won't get the same traction. And as I say, when we say illegitimate force, we're talking about things that were different to what was shown on the Medway expose, which was generally on the lower end of illegitimate force, I would say. You know, it was talking about speaking disrespectfully about children to children and provoking them in a way that staff, and I don't mean to minimise that, but you know, there are lots of occasions where illegitimate force is used in prison. But what I would say is that legitimate force looks awful on when you see a film. So I watch acres of this stuff, you know, and what you have is a fight, right, where there are rules on one side of the fight. So you have members of staff who are basically protected by a uniform, and they are facing in children's institutions very high levels of violence, and they have to intervene. And I will defend very, very robustly members of staff from protecting other children often and their colleagues from harm. I've seen videos where members of staff are crouching around a kid's head as 10 of their counterparts are trying to stamp on it. I've seen, you know, lots and lots of courageous and heroic work being done by prison officers. But I think to get to the point, the way you stamp this out, I think, is you start reducing the whole. I think illegitimate use of force is a function of the whole use of force. Maybe it's 1%, maybe it's 10%, we can argue over that. But if we have less use of force because we reduce the amount of violence by effective behaviour management, then we will have less abuse. But absolutely, I wouldn't pretend in a Mumford Sundays that we report it, but we do report on illegitimate use of force in those terms.
Now, if very quickly we're going to move on to Kate, who hopefully will end on a slightly more positive, optimistic note in terms of reducing the overuse of police detention, custodial remand, and indeed sentences. And I think we're going to have a very quick whiz through, because then we've got a fantastic performance to go through food and drink.
Yes, well, it's always hard to present at the end of a day and when you stand between food and drink. So I will be quick. I can't promise to be completely uplifting, but I do think that what we've learned today is that listening to each different professionals working, different specialism, working, defending children's rights, that we really can learn from each other, feel re-energised and re-motivated, to redouble our efforts to ensure that we are standing up for children's rights in the different roles we play in their lives. I always talk about children, and it may not have been noticeable to you, but it's noticeable to me that our judicial lead for youth, Mrs. Justice May, uses the term children. You hear judges saying, well, you can't reasonably be expecting me to describe this 17-year-old as a child. Yes, you can. And actually what we know about the brains of teenagers is that they're still developing, and the children who tend to be in the criminal justice system have suffered trauma. So actually, developmentally, their age is probably far lower than their emotional and developmental age is probably far lower than their chronological age. It's really important to call them children because they are entitled to special protection. And we talk about, sorry, I was trying to skip through them. It is important, it's a fundamental principle of the UNCRC that custody should be used as a last resort. We have a principle which has been established by the Youth Justice Board that is an evidence-based strategic approach of child first. And this is the point Angus is making, that fundamentally our youth justice system is criminogenic. So the more system contact, the more likely these children are going to stay within it. So everything should be underpinned by trying to divert children away from the formal criminal justice system. But it's also about not managing risk, not looking at what the response of the criminal justice system to manage risk, but actually looking at that child individually and how we can build on their strengths. And that is a challenge, I think, for sentences, but Mrs. Justice May, in the case of ZA, has laid a roadmap for how we can put our sentencing notes together such that a root and branch difference of approach is possible. And we have to put front and centre of that work the evidence that children, particularly black boys, are discriminated against in the process of going through the justice system, and they deserve a fairer process. And the core principles underpinning the youth justice system is that it should be to prevent offending, and that we should have regard to children's welfare, which is replicated in Section 11 of the Children Act, but courts are bound by it under Section 44. And there was a question about effective participation, and how, I think it was from Amanda, about in the family justice system, that's now a responsibility on every participant in the family justice system. Well, it's there in our criminal procedurals that we have a duty to have regard to we must take every reasonable step to secure the effective participation of every person, including the defendant. So that is what we should be doing. I was just going to quickly talk about child arrests, and obviously we've talked about disproportionality. I didn't look at diversion, which is a really good point, which is why we have the disparity in outcome. We have 94,000 stops and searches. Only 9% of them result in arrest. So many children are having negative experiences of the police, traumatic experiences. Black children 6 times more likely. Routinely, they're being stopped and searched. It's not resulting in a police investigation, but they're having that negative experience that then informs their behaviour the 2nd, 3rd, 4th time they're arrested, and they're not willing to be compliant, and then they kick off, and then they get arrested for assaulting a police officer, and they come into contact with the criminal justice system, and sadly they stay within it. So we need to be really robust in how we represent those children to try and stop them being dragged in into contact with the justice system right at those early stages. Those very low level offences are where it all starts, and where we have to try and take steps to stop it. In terms of police detention, we've got nearly 55,000 child arrests. According to Vicky Kemp, who was started off today, in 99% of all cases, the custody sergeant just automatically says, having been arrested, yes, I'm going to authorise your detention. So by my maths, that's nearly 50,000 children who are detained in police cells. That's a projected number, because we simply don't know, because other than academics like Vicky Kemp shining a spotlight on this, we are not recording this data. We're not disaggregating and finding out how many children are sitting in police cells. Down to her research, we know on average they're spending 11.5 hours. 11.5 hours. Have you spent recently 11.5 hours without your mobile phone in a room with no clock? I mean, it's incredibly traumatizing, and that trauma is going to inform all other contact with the justice system. And it's not a surprise that we do see Angus's example of that low-level contact with the justice system gradually escalating up towards custody. 60% of those children, having spent on average 11.5 hours, and some longer, end up being NFA, which means no further action. But there are 17,000 charged. I mean, that's days and days and days and days and days of time children are unnecessarily spending in custody, because if you listen to what Sarah Hemingway has established with the law, most of those arrests will not be proportionate or justified, because actually what the police can do is arrange for that child to come to the police station and have what's called a voluntary police interview. Now, for police station lawyers, they'll say there needs to be better protections around that, and they really do. But if we stopped automatically arresting, incarcerating at the police station, we would change the whole face of how we treat children. And that has to be our starting point, because if we did that, the opportunity for lawyers, if they were properly paid, to intervene at that early stage and make sure that black children got those same opportunities to be diverted as white children, because there wouldn't be a pressure and a time, people wouldn't get lost in the system. Sometimes at the end of that that time in the police cells, and maybe they have routinely been released under investigation, they may be bailed, there may be a long delay before a charging decision. So that opportunity to push for diversion is lost. But if we stopped right at the beginning, stopped automatically detaining at the police station, we'd have a lot of opportunity to ensure that diversion decision was properly scrutinised, and we could start to address the statistic which ends up with more than half the children in custody are from minority ethnic backgrounds, when they only make up roughly 18% of the general population. And that's informing the journey of this group of children and young people, because they're looking around them and it's a self-fulfilling prophecy. They haven't got good role models to draw them out of that cycle of behaviour. And in fact, one of the things that makes me so cross, and now I'm on a rant, is that these children don't have choices. When we talk about children making bad choices, I don't think that's fair for many of these children. When you read about the backgrounds of how children become drawn into county lines, when somebody aged 10 is being offered a brand new pair of trainers, and they don't have a pathway ahead of them where they're going to go to school and then they're going to go to sixth form and they're going to go to university and they're going to have a legitimate source of income, they may not see ahead of them a legal way to be earning money, and they get offered a pair of trainers. They don't want to be at home because it's chaotic at home and there's a lot of violence and trauma that are suffering there, and somebody's offering them a brand new pair of trainers. I don't think that's a choice, and we need to support those children rather than punish them. We've heard about remand. Angus has shown us this is the number of children in custody, and that's the proportion of them who are on remand. It's been steadily rising, and again, Angus alluded to this. 73% of children who were remanded in the secure estate then go on to either be acquitted or receive a community sentence. So it's wasted time, because while you're on remand, you're not doing the work towards resettlement. You're not receiving the benefit, which if we had a functioning secure estate, you may be able to benefit from being incarcerated. None of that, everything stands still, and you get, actually, it's a barrier to you receiving support and intervention. And particularly those who've received trauma, they're not getting counselling and therapy that they are entitled to. Everything stands still, and we're really, costing a lot of money. It's a lot of money for the state, and actually we're increasing the likelihood of these children coming back into the justice system. And again, 58% of remanded children are from Black, mixed or Asian backgrounds. So I think we've seen similar statistics from Angus, and this is really interesting how they're now presenting statistics. On the top line is white children, so it gives you the impression that they are the largest group in the in custody, but actually you have to look at what these lines represent. So this is Black British, this is mixed ethnicity, and this is mixed Asian. So then if you push those together, you see that, in fact, they make up more than half the custodial population. And it's also, Angus said there's around 400 children in custody. In fact, when you put 18-year-olds in that, there are nearer 600, just over 600. And of course, many of those 18-year-olds would have been children when they offended.
All of them.
All of them. And because of, partly due to the delays.
They wouldn't be there if they weren't. They're held back. You don't go to these places if you're 18.
Right. So there you go. So although it is a success story, there are less children in custody. It's really a horror show. And I would be wrong, because I've done some recent work, and there's some representatives of an organisation here called the Drive Forward Foundation. The research we were looking at said 59% of children in custody care experience, but Angus's research yesterday said 66% of those children who filled out his surveys reported having been in the care of the local authority. And I suspect it's even higher, because children who have had some support from local authority, who are considered children in need, may not have recognised themselves as of being carers experienced. And when we layer in this disadvantage, and I think we probably don't talk enough about class, and Angus is saying that he never sees middle class kids. I think a lot of this is about class, but when we layer in ethnicity, 1 in 20 care experience children receive a custodial sentence by the age of 18. It's 1 in 10 if you are black and a mixed ethnicity. 1 in 10. Can you imagine that group of children lined up in primary school, and by 18, one of them is going to be in custody? And in fact, when I hear young people from the Policy Forum Drive Forward talking about their experiences, many of the children that they knew in the care system are now in prison. So we need to be bringing the background of these children to the forefront when they go through the justice system. There it is, criminal procedurals, every reasonable step to facilitate the participation of any person, including the defendant. From Thompson and Venables, way back in the day, we're talking about dealing with children, taking account of their age, level of maturity, intellectual and emotional capacities. Every child has the right to have their feelings taken into account. They have a right to have agency and decisions being made about them. So, So what we need to do is take away from today is we need to make sure that child's voice is heard at every step for us in this panel of the criminal justice process. And I believe if we did that properly, if we made sure they were heard at every stage of that process, we could really start to challenge the cycle that drags children into it. So at that decision, at the police station, if you see a child being arrested in the street, say to the police officers, do you have to be doing that? Couldn't you just make arrangements for them to come down to the police station and they say, we need to start challenging this front and centre and to break the cycle, to get less children in a secure state so that one day it could be more functional and support them so that they can go on to fulfil their potential. Because as Lady Justice May said, these are not bad children. They've got so much to offer, and we really are failing them by not giving them the opportunity to go on and fulfil their potential. And with that,
I know, with that note of hope.
I was